Can you please?
On restoration application that took 5 minutes.
Restoration.
Restoration.
My lord, on extreme urgency, my lord, I am asking for a leave before your lordship to move this application with a short service at 2 p.m. or at tomorrow at latest by 10:30. My lord, my property, I am the owner of the property from 2020. Bank suddenly came and pasted a notice on my property saying that you have to deliver possession by 28th of April. Notice belongs to somebody else. I am out of blue. I have no nexus, no connection, whatever has happened. Immediately, I made a police complaint. Thereafter, bank has stated you have to immediately deliver vacant possession of the property on 28th April. My lord, kindly see the notice. Notice is also not in my name. I have the conveyance deed. Thereafter, I am paying tax. Mutation is my name. Everything, every compliance.
Of the bank.
My lord, I will make a short service to the bank. Otherwise, they will take and they are coming with different mails, around 10 to 12 people. I have no nexus, no connection. My lord, I am led by Mr. Subhashi Sengupta in this matter.
The date has been fixed on 28th. Lordship, this notice, no notice 13-2, 13-4. Even the properties, your lordship, is not described. Your lordship, I met with the officers. They are saying that they have obtained an order. Even the DM's order is not against me. That's my problem. I made a police complaint. Nothing, your lordship. That's why, your lordship.
Tomorrow.
I'm grateful, your lordship.
My lord,
That's
may
how
I be
we all the
permitted to
parties-
mention one matter, my lord, for inclusion in the list? What has
Inclusion
happened?
next week, madam.
My lord, kindly, it is a bit urgent because
Next week, madam.
next week.
To mention one matter for upgradation, my lord. Disappearing.
Upgradation next week.
Lordship,
Don't mention it.
Lordship, may I be permitted to mention a matter for
After 2nd of May.
extension of interim order, Your Lordship? The interim order is expiring on 25th, that is tomorrow. Your Lordship, this matter pertains to the urgent determination of Justice Sinha.
Why are you coming today?
Lordship, the interim order is expiring tomorrow. So, Lordship,
Nothing
can
doing. It
reflect
can only come up next week.
Lordship, let it appear then next week. There are two applications. One is expiring.
You have waited till now. Let it come before Justice Sinha's board. What is the urgency? You have waited
Interim order
this
will
long.
expire on 25th.
That's all
If
right.
the order
sir.
is of
Can't come on the last day.
Lordship, the other matter is on 30th. If that will be
Nothing.
Lordship, the other
Mention
30th
before the
on
regular
April,
bench.
it will expire.
My lord,
Regular bench.
kindly,
Yes.
may be permitted to mention one original side matter, my lord. The interim order is expiring next Tuesday, my lord. Why I'm mentioning, my lord, because this benches takes original side on Thursday. By Thursday next, when the matter will come, my lord, the interim order will be expiring.
My board.
No, my lord, the order passed by Honorable Justice Kaushik Chandra while taking my lord,
Municipality
municipal
matter.
Yes, my lord.
Municipality matter.
Municipality matter, but the interim order is very much restricted.
Give it.
Even it is today's list, it is appearing as item number 70.
Give it.
My lord,
Yes, Mr. Bas.
Compelling circumstances mentioned this matter.
No.
Yesterday, municipal building tribunal refused to grant anti-claim stay of an alleged illegal structure in a conference. Corporation had taken a regularization fee regularization. Even then, because the corporation had passed an order for demolition of a structure, and yesterday only a memo has been issued, no order has been granted. Information slip I have obtained saying that you are here for interim order rejected. Corporation has given a notice under course of I-45 of the KMCR. They are coming today at 3 p.m. in order to demolish. 11. Number 3. So, appeal is pending before the municipal tribunal. The entire appeal will be in fact.
Tomorrow.
my lord,
This is where the client is fair winner. They will put their hands on this winner. I see whether harvest and leak. If your lordship's court officer does not write winner that link is banned, department will not allow filing. So winner I'm sitting. I'm going to stitch it and winner I'm beginning to select it within 5 minutes.
Give it.
my lord has been,
Miloj, may I mention a matter, Miloj?
has been
It's a original side matter.
Appeal itself.
happened.
Tomorrow is the day.
My lord has been kind enough to get the slip from me, but my lord, the matter will be appearing, my lord, it is appearing in the list as item number 70. If in case, my lord, the matter is not taken up today, by the time, my lord, the next week, the interim order will be expiring. So if your lordship kindly be pleased to extend the interim order or pass final appropriate order related.
Sir, the matter will be listed tomorrow.
Oh, I'm grateful, my lord. I certainly right.
Miloj, may I mention a matter, Miloj?
आज अगर नहीं आता है तो listed tomorrow.
The lordship may coordinate one matter for exploration application.
Restoration.
Miloj, may I mention a matter, Miloj?
But I'm mentioning.
Wait.
But I'm mentioning a matter of Honorable Justice Sinha's list, my lord. But here what has happened is, my lord, the hawkers in the railway area of Srirampur has been asked to vacate the premises because there will be a demolition undertaken on 26th. But there was already a writ petition, my lord. An order was passed so that a hearing is given and a reasoned order is issued. My lord, the reasoned order was not served upon us, my lord. In the meantime, my lord, there was in one of the days, my lord, when there was a no adverse, my lord, the matter was taken up, my lord, and there was an order of dismissal without an ex parte dismissal. My lord, we have filed a recalling application, my lord, and 26 they have, the moment that the dismissal came up.
Nothing doing, Mr. Nag, you come later. These
But
are all
26 there will be a,
encroachments, Mr. Nag, regular bench.
but it's
Yes.
not about encroachment, my lord.
These
We
are
have-
all encroachers sitting on government land. Yes.
My lord, there are meetings we have held with the Minister of Railways.
Nobody
Today
will do
another meeting
anything.
is there, my lord.
Mr. Nag, nobody will do anything only in
Only-
accordance with law. Yes.
Lordship,
Permitted to mention one matter. A writ petition was filed on 18th February 2025. Since then, matter has not been included in the list. Kolkata Municipal Corporation without
Mention it next week, madam. We'll upgrade it.
Quickly to mention a matter, my lord, on notice I am mentioning, my lord, it is probably the 5th or 6th item under the heading hearings in today's list. My lord, the difficulty is, there was the issue pertains to trade license of the company. This is a factory which is in Belur, my lord, 1500 plus employees are there. My lord, the difficulty is the trade license had expired, there were direction for issuance of the trade license, and still, my lord, the trade license has not been renewed, my lord, despite making request. My lord, I'll be fair, I have filed a CPAM also before the Honorable Justice Justice Chando. My lord, we are trying for that also to be lifted.
Try for that.
My lord, this is the main.
Try for that. Try. No, don't take it right now. You try for that.
Lordship, may I?
Permitted to mention one matter for upgradation, my lord. This is matter relating to
Upgradation from next week, from 2nd of May.
Lordship, may I humbly beseech your Lordship, the other matter in which the interim order is expiring on 30th, Lordship, that interim order may be kindly extended. Also, with respect to Justice Sinha's determination, urgent determination, Lordship.
Filing on 30th.
30th of April, Lordship. Grateful.
My lord,
Grateful, Lordship.
may I kindly to mention a matter for extension of interim order, my lord. To
Whose
the-
board, madam?
I am for the petitioner.
Whose board? My board or Justice Sinha's board?
No, my lord, this court
This board. When is it expiring?
expired on in the middle of April, my lord.
Already
Today-
expired.
Yes, my lord. Today the matter is serial number 74, my lord.
We'll see if it comes today.
My lordship, I am mentioning for our urgent listings of our Justice Amrita Sinha list. The reason for urgency is in Fred petitioner. The matter for the premature release was recommended by the state's review board, but the petitioners has not been released due to bureaucratic notice delays. So, my lordship, it's my humble petition. Please, urgent
Premature release of money. What is it?
premature release by the recommended by the state sentence review board.
Before the regular bench. Yes. Call out the regular matters.
May I mention a matter, my lord? May please, my lord, may I mention a matter?
number 1.
Yes.
My lord, I am for the petitioner. I had mentioned the matter yesterday, my lord, for extension.
Yes.
My lord, the interim order is expiring on 30th of April, my lord. My learned junior is there. He'll hand up to your lordship the order of Honorable Justice Amrita Sinha, my lord, of 20th February 2025. Kindly, my lord, extends it, my lord.
This is item 1.
Item 1, my lord.
Just a minute. Mr.
Please,
Cat,
my lord,
which
please, my
matter?
lord. My lords, this matter pertains to Justice Sinha's board. My lords, there is an urgency in this matter. My lords, may have it at any point on this week or
What is
next.
the urgency, Mr. Cat?
My lords, as per this scheme, my lords, we have only been granted part subsidy. My lords, rest also some more than 3 years have passed. My lords, we have not been granted any subsidy. My lords, I have
No,
to
no,
pay.
no, Mr. Cat. No urgent hearing.
My lords, more than 75 lakhs is due. My lords,
No
more than
urgent hearing.
100
No urgent hearing. Sorry, not in this matter. Not in this matter, Mr.
Only
Cat.
requesting for a next day, next week.
No, let it be before the regular roster, Mr. Cat. No urgent hearing in this. Yes, call out the
Please.
list, yes. Yes, item 1, right?
Yes, my lord. The Honorable Justice Amrita Sinha had passed an order of 20th February 2025, by which the interim order was extended till 30th of April 2025.
Yes,
It was
what-
granted earlier.
Who's the other side?
My lord, the state of West Bengal is the other side, my lord.
Who's appearing for the state of West Bengal? Have you served them?
Mr. Ayan Bhattacharya was appearing, my lord, all throughout.
Just take down. The interim order that is subsisting in the matter is extended till till 31st April 2025 or until further order, whichever is earlier.
My lord, 31st April.
Yes,
My lord, the honorable judges, I believe, coming back
on
on,
second,
my lord, on
Oh,
second,
till
on
15th of May.
my
15th
lord, my lord, deeply obliged.
or until further order, whichever is earlier, liberty
My
to
lord, deeply obliged.
the matter on hearing, for hearing. Liberty
My
to
lord.
matter for hearing.
So deeply obliged.
Item number 2.
My lord, I'm for the petitioner. My lord, there has been a big bereavement in the family of the my lord, the head advocate on record. My lord, she has to rush to her native place, my lord, yesterday night, my lord. So kindly adjourn the matter for my lord 7 days, my lord.
So I'm for the respondent number 7 in this matter. This is a restoration application filed by my learned friend.
Yes. Any objection?
My lord, all the files are lined with the
Not today. Not today. Yes.
Item number 3.
I apply for the Kolkata Municipal Corporation.
Yes.
I am
Mr.
giving a report to your lordship there, but I cannot say, my lord, that the much development has taken place after the last order, my lord, regarding the actions against the unauthorized construction for demolition.
Then what is the point of giving a report?
No, that is the report. That is the reason I have asked my officers, my lord, that already some time has already passed. Be up and doing and get the things done with the help of the police, because police has to vacate the premises.
Yes.
Therefore, my lord, leadership direct that as explicitly as possible, and in terms of the earlier directions to execute the orders of the demolition as well as taken by the authorities of the Kolkata Municipal Corporation. I have submitted on earlier occasion, time and again, the report from time to time. The developments were taking place. The court is kept the matter pending for my consideration that how much progress.
Send me the report.
And the petitioner is not coming. My learned friend, my lord, is making an application to be added as a
This
party.
is an instruction, Mr. Goel.
That's
File a
of course,
report.
my lord, that is of course, my lord.
Please file a report, Mr.
My
Goel.
lord.
My lord, if
My lord, your lordship gives me
Mr.
some more
Ghosh.
time so that I can, my lord, proceed with the work, my lord, and can come with that. That action has already been resumed for, my lord, in terms of the earlier order of the court.
Mr. Ghosh seeks further time.
My lord.
Speaks to file.
Kindly hear me out. They have come out with whatever the instruction. Kindly see point Roman 10 A under point number A. They have said that stop work notices have been initiated and local PS and demolished portion of unauthorized construction happened. Now come back to the original report which was submitted, and it was basically on the basis of this report the whole demolition occurred. They had misguided this honorable court completely by this report. In this report, they have completely outrightly said that there is no sanction plan. By the way, I have to show before this honorable court, I have a valid sanction plan. They have been taking taxes from us, and we have a valid sanction plan. They have given. It is a valid sanction plan. Submit given by them, and their authorities have signed. If I may submit to them, there is the authenticity in this, and they have outrightly on the first place, my lord. If I may, this executive engineer at that time had completely in collision with. I come with a very heavy heart. I no offense to my counsel appearing for KMC. This executive engineer has completely acted in collision and connivance with the petitioner because he only misguided the honorable. Kindly give kindly let me complete. He basically diverted the honorable judge's mind for the demolition. Demolition happened on the basis of this report itself.
Why are you excited, sir?
My lord, pardon. Because I come with. They are going back from the stand. Very sorry, my lord, but they are going back from the stand. Whatever I have heard from you.
It's not a theoretic.
Okay, my lord.
What is happening?
Pardon me, my lord, but I come with a heavy heart because I couldn't sleep because this is happening.
No, you should sleep well. Then you'll perform well in the.
I know, my lord, but you know, it's the start of from my profession. I have to. It is very hard for me to.
The court is hearing you. There's no.
Yes, my
need to
lord.
be excited.
Yes, my lord. My humble sorry.
Slowly and clearly, it will be better for you so that I can also understand what you're trying to.
My lord, if I may go down step by step, my lord.
Step by step.
Yes, sorry, my lord. Yes, my lord. On the earlier occasion, the demolition happened on the basis of the report which was submitted at the instruction of the executive engineer.
Respondent number what?
Dated.
Your petitioner or the respondent?
My lord, we have filed for addition of parties since we are the owners of the said premises number under the, and we have been paying mutation taxes, and we are mutated owners under the same. So they at the first place they did not make us party outrightly in that writ petition in which they obtained a demolition order against us at the first place. On the basis of demolition order was passed on the basis of the report dated October 2023. My lord, if you may, Annexure B, page number 7. Annexure A, Annexure B, page number 9.
Of your application or the main writ?
Of the main application. Annexure B, page 9. It is a report. Yes, ma'am.
Yes.
Report yes, my lord, if I may come to the page 9, my lord. If
yes, I'm on page 9.
Number 9, serial number 9, my lord.
Yes.
It is written 20A, the premises number, of which I am the mutated owner of the same. Vijala Road, Calcutta 46. Constructed 4-storied RCC without any sanction plan. They have admitted at the first place that there is no sanction plan.
Yes.
But they themselves have given a sanction plan, and their authorities have also signed, and we have obtained the same in the usual procedure, whichever is opted for that.
Where is the petitioner?
Petitioner, my lord, he has been absent. I have been serving him constantly. The advocate on record for the petitioner refused at the first place. He did not give me any application. She refused to entertain my clerk. She refused to entertain me. I had to post directly to the petitioner. The address was unknown. Whatever they have filed, petitioner has filed an address which is unknown.
Yes.
You. Right. My lord, kindly take step against this executive engineer. He has falsified a document on the plain sight. He has basically misguided the court, the honorable court, to get an order in the favor of the petitioner outrightly without even giving us a necessary opportunity of hearing. Outrightly, blatantly against the principles of natural justice.
petition.
So there were total how many structures? 9.
Total, my lord,
18. 18, my lord.
18.
18.
Number of premises was, my lord, given in the petition, and the court directed us to make an inspection and submit a report. Inspection had taken place time and again, and each of the premises, now Malan is contending that it has been said that one occasion it has been said that without sanction, but subsequently it appears that 400 subsection 1 proceeding was initiated against the person responsible. The action had been taken in December 2023 and 2024. Well, when the petition was visited and the action was taken, he has taken the long 1.5 years to come before this court. He got the opportunity to approach this court. Well, I'll take.
But action was taken on the basis of that order.
I have taken specific instruction with regard to that, whether building plan has been going. Even the building plan is sanctioned, the unauthorized construction can be placed, my lord, despite my deviation from the sanctioned building plan.
But you had admitted without sanction plan in the first place.
That's the difference. I'll take specific instruction. The proceeding was initiated.
This means he was not instructed properly. This means
Well, you were so long, 1.5 years.
Take down. Learned counsel for the respondent corporation has not filed the updated status report indicating the demolition action taken upon the unauthorized construction. It seems that the officer concerned of the corporation is dragging his feet despite various orders being passed by this court. Still, the complete demolition action has not taken place. The respondent is granted further 4 weeks time to file his report, and it is expected that the complete demolition action in terms of the earlier order passed by this court shall be carried out before the filing of the next report. Full stop. Learned counsel for the respondent.
He's making an application to be added to the party.
Respondent.
Necessary
An application has been filed by one Mr. Rajendra Ram, right?
Rajendra Ram, the petitioner.
Rajendra Ram, who claims to be owner of property.
Petitioner.
He's a petitioner.
Petitioner, my lord. The owners whom we are.
What is your name?
What is your name?
My lord. Rajak, my lord.
Is filed by one Mr.
My lord.
An application GA number
Sabitri Rajak
and
others.
GA1 of 2025 is filed by
Sabitri Rajak and others.
Savitri Rajak and others, claiming to be owner of premises number
28
Iljala Road Police Station, Karaya, situated in ward number 65, borough number 7.
46, Kolkata.
Full stop. Learned counsel for the impleader. Applicant, learned counsel for the applicant states that his building is constructed wide valid building sanction plan number 200700043 dated 1st October 2020. Full stop. He states that there is no illegal or unauthorized construction being carried out by the said applicant. Full stop. He has further stated that even the property has been duly mutated in his name. Wide mutation dated 27/7/2019. Full stop. Learned counsel for the respondent corporation shall verify the said fact, and if found that the applicant is living in the above mentioned property, is applicant has a valid sanction plan for the above mentioned property, no action shall be taken on the same if there is no illegal or unauthorized construction found on the said property. Full stop. Let this fact be verified by the corporation, and report in the form of affidavit in the form of report, or report in the form of affidavit be filed before within a period of 2 weeks.
The University is submitted, we have granted 4 weeks time. So far as this is 2 weeks, we are University asked me to submit the report 4 weeks time.
4 weeks for the entire demolition.
Or entire.
Yes.
Actions valid for
action. A copy of this order shall be marked to the commissioner to ensure that appropriate action is taken and the corporation doesn't drag its feet, as it is evident that despite several orders being passed by this court, no action is being taken.
Action has been taken
to the satisfaction of this court.
So far as this case is concerned, 20A
to the satisfaction of this court.
So far as this case is concerned, 20A for which my landlord has applied for, in the event where there is no unauthorized construction sanction plan, he is saying, I am accepting that. In the event no the unauthorized construction deviation from the sanction plan, no actions to be taken.
No deviation, you will take action. I have already stated so.
My lord.
Only sanction plan.
Of course, my lord. Your sanction part,
deviation,
sanction part not to be done.
not to be touched. Any deviation, you will break it down.
But earlier occasion he had stated no sanction plan outrightly.
That's all right. We'll see that.
Much obliged. And my lord, pardon me if I had gone a bit hasty. Pardon me, my lord. It is starting. Pardon me. I need to learn a lot from your lordship and other lordships. And other. No. By getting this I need to learn from him as well. But getting it from you,
he can twist anything anyway.
From next time, I'll go step by step. Actually. Okay. Thank you, my lord. Grateful, my lord.
Item number 4.
My lord, I appear for the petitioner. My lord, I'm sorry, I'm appearing virtually. My lord, kindly sees my lord's last order of 10th of April 2025. 2 weeks time was given to the corporation to conduct an inspection and file a report in terms of a previous order. My lord, that inspection as of now, my lord, has not happened, and we have not been provided with any report.
Yes, Mr. Ghosh.
Well, the inspection had earlier been taken. Of course, my lord, I do not know, my lord, the court, my lord, I'm extremely sorry, my lord, so far the report is concerned. Inspection at the premises in question had been taken place. My lord, it was found that certain construction have been taken, my lord, without, my lord, providing any, my lord, sanction plan. Therefore, 400 subsection 1 notice was issued. My lord, we were at the stage of, my lord, proceeding with the proceeding, my lord, under section 400 subsection 1. Well, at that juncture, my lord, he came to the court, stopping us from proceeding with the actions.
No, but I have not passed any order stopping him or stopping.
No, my lord, earlier occasion, my lord, the court is certain, my lord, the court directions, my lord, that he should, my lord, go on with the construction works as he suggested before the court. But the court, my lord, that, my lord, benefit, my lord, he has constructed in terms of the court's direction. the other coordinate bench, my lord, passed their directions.
8th October.
My lord, 8th of October, there is an interim order. This is a advocate's chamber in 6 Old Post Office Street. My lord, only repair work was going on without any notice of whatsoever nature. My lord, suddenly, my lord, somebody came to the police station to stop the work. Thereafter, we were compelled to, my lord, institute this action. And the my lord, judge was pleased to, my lord, pass an interim order upon satisfaction of a prima facie case.
He said mezzanine floor has been found that mezzanine floor has been constructed and certain other construction works.
File your report, Mr. Ghosh.
My lord.
You carry on with who's stopping you? Only to the extent of
No, my lord, the
repair
court,
work.
my lord, the earlier occasion directed to carry out certain works which he proposed before the court.
Yes.
Therefore, my lord, we took it that when the court has asked him to go ahead with the work of construction as proposed, my lord, by the petitioner, then, my lord, possibly, my lord, I am handicapped to proceed with our actions. Because, my lord, unless the court, my lord, grants me leave, my lord, to proceed with the unauthorized construction, if any, after giving notice to the parties and providing an opportunity of hearing, but that possibly, my lord, my authorities, my lord, in difficulty. Because when the court has that these are the construction, you go ahead with the works. But which, my lord, according to us, not, my lord, without any sanction of the building plan.
My lord, it was a renovation work in a lawyer's chamber, my lord. We had clearly described it in the petition. The learned judge was pleased to, my lord, see that, my lord, averment, and thereafter, my lord, this prima facie case was, my lord, considered and an interim order was granted. My lord, repeatedly, my lord, the corporation was granted opportunities to inspect and file a report indicating if there is any violation of any of the provisions of the act. Till date, my lord, that, my lord, action has not been taken. If Mr. Ghosh says he doesn't want to, my lord, file a report, lordship may hear the writ petition itself, my lord.
But whatever he is arguing petitioner, he can take all this plea before the corporation if the corporation conclude the proceedings.
This court-wide order dated 8th October 2024 had allowed the petitioner to carry out the repairing work at room number 2062 on the first floor premises number 6 Old Post Office Street, which does not require any permission from the Calcutta Municipal Corporation. Petitioner states that he is only carrying out the repair work, full stop. The contention of the petitioner is refuted by the counsel for the respondent, Calcutta Municipal Corporation, full stop. Mr. Ghosh submits that since this court has permitted the petitioner to carry on with the construction, they are not able to go and inspect and file a report as to the nature of construction which has been carried out, which is not in accordance with the regulation allowing repair of the property, full stop. It is made clear that the corporation shall go and inspect the property and ascertain if there is any illegal or unauthorized construction which is being carried out in the above said property, full stop. Any repair work which is done in accordance with the building bylaws shall be permitted, and there shall not be any disruption in carrying out the repair work, full stop. A report to this effect shall be filed within a period of 2 weeks after carrying out the inspection, and the corporation shall not take the stand that this court had restrained them from conducting any inspection and finding out the deviation and other unauthorized construction on the said premises. Full stop. Let this matter be listed after 3 weeks.
3 weeks.
You carry on the inspection. This is all way. No, Mr. Ghosh, this shows how much you don't want to work and how you are just dragging your feet, coming up with lame excuses, just trying to twist things from here to there.
Grateful, my lord. Grateful.
Nothing else.
Item number 5.
I'm appealing for the Kolkata Municipal Corporation.
At 5, I was appealing for the petition and led by Mr. Ghosh, my lord.
Well, this is a case for compassionate appointment. Well, this second round of litigation, and the court initially passed an order. If Lordship looks at the order, the other court bench of 19th of March.
Which page, Mr. Ghosh?
19th of March, the court passed an order.
Which page?
Not in page, my lord, in the order sheet, my lord.
I have filed my report, my lord.
যেদিন এখন হচ্ছে সেদিন তো এতগুলো রেকর্ড নিয়ে নিয়েছে এই দেখো 11/4
রিসিভ করেছেন এটা আমার তো কপি দেয়নি
You file your exception. I'm sure you'll file.
They have filed the exception, but they have submitted the report. I am filing my exception to this the report.
I have not received any copy of the
And I have shared to the advocate on record on the very day, which was it is as FR 7 days before.
Copy. Calcutta Municipal Corporation has filed its affidavit and opposition.
So, they have corporation has filed
report on behalf of the report filed on behalf of the Calcutta Municipal Corporation is taken on record. Full stop. Learned counsel for the petitioner states that he has filed his exception to the report. Copy of the same is taken on record. Learned counsel for the respondent KMC states that she has not received a copy of the exception. Full stop. A copy of the same shall be supplied to the respondent KMC during the course of the
I have given to the learned advocate on record.
Give another.
But I have given another, that's a divination, but I had already served.
Give another copy. Just,
I'm giving another one.
just take down. Another copy has been supplied. Wo hata do. Copy has been given in the court. Copy has been given in the court. Let this matter be listed for hearing. We'll keep it for hearing
Lordship.
next week.
Any day convenient for your lordship.
When do you want, Mr. Goel?
Next week, my lord. Because the compassion appointment, you should either way decide the issue, entire issue, because they have given certain reasons. I have taken on the face of the scheme they have framed.
Next week we'll finish.
Fine.
So next Thursday.
My lord.
Next. For hearing, kar dena. Just put in the category for hearing.
Well, if your lordship put in the category of hearing, well, it may not reach your lordship.
All right, then just let it be in.
My lord.
For hearing.
For hearing. Item number 6.
Well, I am for the petitioner. Petitioner বলতে দিন আমি petitioner হ্যাঁ হয় আমরা petitioner না হ্যাঁ ওকে বলছো কমন মিস্টার দ্য অ্যাডভোকেট who are you?
Item number 6 তো অনুরোধ লাগে
অনুরোধ
Your Lordship, in item number 6, I am applying for the petitioner.
সই করছেন এখানে
Your Lordship, my instruction is to withdraw the writ petition of the client. Only Your Lordship, our liberty may be granted to approach before the tribunal.
I'm not granting that liberty at all. Whatever liberty you have in accordance with law is always when it comes for the petitioner seeks to withdraw the present petition. The same is dismissed as withdrawn.
Item number 7.
I'm being led by Mr. Sen. The other side was addressing on that IBC issue, my lord.
I was giving
Mr. Sen is on.
I was giving a reply. I was in
Yes,
the
yes.
midst of my argument.
So Mr. Sen will give the reply, and I'll take notes.
Should I proceed if your lordship permits?
Yes, yes, absolutely.
My lord, the writ petition epitomizes a challenge to the process of valuation and determination of the valuation of a building. Now, my lord, if your lordship kindly takes the prayers which are at page which are at page 26 onwards, your lordship would find that the writ petition relates to a challenge to the process of valuation and determination of valuation, page 26. Prayer A, prayer B, everything is that.
Now, at the time of argument, these prayers were jettisoned. My learned friend came up with a plea that, you see, I have been declared to be a defaulter by the RBI. And from 21, that proceedings, CIRP proceedings started. It ended in 2023. So, I am under the IBC. I am immune to pay any tax. I will not pay any tax. Corporation cannot demand any tax. Your Lordship recollects the argument. He did not go an inch further. His entire gamut of argument is within that periphery. That under the terms of IBC, I am not supposed to pay you a penny. Even if you have any claim, it has extinguished. Today you cannot claim anything. This is the sum and substance of the argument. My lord, it was my endeavor when I opened my argument to show that whether this writ petitioner does have any locus to move this writ petition. My lord, I took your lordship to his pleadings at paragraph 4.
Yes, sir.
Your lordship has taken a note, and thereafter, this is his clear statement. The board has been made defunct by appointment of an administrator. And thereafter, my lord, I showed your lordship the NCLT orders. NCLT orders, which also states this, that the board has been superseded, administrator has been appointed with 2 persons who are going to assist him. So board is no more there. There is no pleading in the writ petition or any document in the writ petition to show that the RBI has again reinstated this board into function. That being not there, my point was the writ petition is per se not maintainable, because this board could not have entrusted the petitioner number 2 to file the writ petition, and the petitioner number 2 has affirmed the writ petition and filed it. So this is relating to the locus and maintainability of the writ petition. Now, my lord, it was also my endeavor to show to your lordship that what did the resolution applicant pray for. My lord would kindly take to come to page 221, who is the resolution applicant, firstly. On, my lord has this in the second volume, my lord.
Yes.
My lord comes to page 221.
Yes.
My lord would find orders. On hearing the submissions made by the administrator and perusing the records, we find resolution plan filed by National Asset Reconstruction Company Limited has been approved with 89.25 voting share. As per COC, the plan meets the requirement of being viable and feasible for revival of the corporate debtor. Who is the corporate debtor? The applicant before your lordship, the writ petitioner.
Yes.
So any grievance, if at all there be any, this NARCL can come up, who is not the petitioner before your lordship. Then paragraph 6, your lordship would find which is corroborated at paragraph 6 of the writ petition. Now, my lord, it was my endeavor also to bring it to your lordship's kind notice. What were the exemptions of? Today he is saying that you do not, I am not, the claim of property tax has extinguished. Now, to do that, let us see what did he pray for. Your Lordship would kindly come to page 198. My Lord would pardon me for I am repeating my arguments.
No, not a problem.
Because I showed your Lordship this document.
Yes, that's okay.
Now, my Lord, 198
Yes.
gives the details of the relinquishment, waiver of liabilities and approvals. It
Yes.
says 112, the relief exemption waiver sought for by the resolution applicant.
Yes.
Who is the resolution applicant? NARCL, not SREI infrastructure.
Yes.
From the adjudicating authority are set out below for successful implementation of the resolution plan. Now, my Lord, I'd be very brief now. The first one, your Lordship sees at 199, relief with respect to the Central Board of Direct Taxes.
Yes.
Then, my Lord, would kindly flip over to page 202. 202, did my Lord get it?
Yes.
This is the second relief. Relief with respect to the Central Board of Indirect Taxes and Customs Ministry of Finance of the relevant state government and union territory. This is the second relief.
Yes.
Then, my Lord, would kindly turn over to page 205.
Yes.
Relief with respect to the regulatory framework. 4. Relief sought under Companies Act 2013. Then, my Lord, would kindly flip over to page 206, the next page. Other reliefs. This is important, my Lord. I want to just place one paragraph up from this.
Yes.
This actually, this other relief is a long one. My Lord would kindly come to 222, paragraph 115, which your Lordship would kindly mark. We have perused the reliefs. My Lord has got paragraph 115.
Yes.
Waivers, concessions as sought and as given in section 10 at pages 105 to 115 of the resolution plan. Resolution plan. While some of the reliefs, waivers, concessions sought by the resolution applicant come within the purview of the code, while many others fall under the power and jurisdiction of the different government, my Lord would mark this, government authorities and departments. This adjudicating authority has power to grant relief, waiver, concession only in relation to the Code and Companies Act 2013 within the powers of NCLT for achieving the objective of the code. No relief, waiver, concession that fall within the domain of other government department authorities are granted. My Lord, I am an authority. He is seeking today the benediction of the court not to pay the property tax, though he has enjoyed the each and every civic amenity while under this process.
Yes.
No relief, waiver, concession that fall within the domain of the government department authorities are granted. The relief, waiver and concession that pertain to the other government authorities, department shall be dealt with the respective competent authorities, forums, offices, government or semi-government of the state or central government with regard to the respective relief, waiver and concession. Well, till today, my instruction is there is no claim from corporation saying kindly grant me relief for this period in respect of the property tax. So, my learned friends, contention relating to non-payment or extinguishment of my claim does not hold any water. My Lord, I do not join issue to the judgments cited on behalf of the petitioner because their authority is in their own self. But an authority cannot apply unless the fact situation in that case applies. But the fact situation is totally different. Moratorium chole geche. Now, the moratorium, the moratorium has extinguished. Milord, kindly take page 224, paragraph 124. The moratorium imposed under 14 of the court shall cease to have effect from the date and order. So, my lord, till now, whatever I have submitted, one part, no locus, no locus to file the writ petition. He is not the resolution applicant. Resolution applicant is someone else who has never paid for any waiver. And even if he has paid for any waiver, that waiver, the NCLT has granted liberty to the applicant to make an application before the appropriate authority who is going to consider the case of waiver, if at all made out. This petitioner does not have any locus. Now, my lord, the tax, your lordship knows better than me. What is property tax? Property tax is a tax paid by an assessee.
My arithmetic is very poor, Mr. Mukerji. My arithmetic is very poor. My maths is not good.
My lord, will not embarrass me in that way. My lord, I apologize. Now, my lord, the question is, the property tax is a charge on the property, and the assessee or the owner or the person liable has to pay it. Now, the question naturally comes for what? The what is answered because the civic amenities are provided by the municipal corporation and various other municipalities in the state. Now, to defray that cost, the imposition of property tax there is.
But how do we deal with the relevant provision of the IBC, which literally itself bars you? The government statutory authorities.
I have shown, my lord, the factual situation over here.
Your argument looks very attractive, and on the face of it, it makes sense also. You know, because if somebody has availed of the state expenses, in the sense the services from the state, then he's liable to pay the property tax. And he can't really, you know, go away from not paying the property tax.
And he has said it is not his case that during this period for which his case of waiver is for 2 years, 21 to 23. When that proceeding started, there are 2 orders, that is 2 NCLT orders. If your lordship sees, one is of they have annexed it, my lord. The first order is of at page 32 onwards, and the second order is at page 39 onwards, from which I have just now placed paragraph 112, 115. These are the 2 judgments, orders. His case is from 8/12/21 till this date. That is 8th of August 23, corporation cannot claim anything.
Yes.
Now, the most startling factor is, my lord, there was an existing valuation. This, your lordship, let me submit one thing. From 1st of April 2017, there was an existing system to determining the valuation of a property, based on which the tax was being charged. Your lordship is hearing these matters. Your lordship would come also, you must have heard. Annual rental value before first
for the unit area.
Yes, the entire rental value was calculated, based on which the valuation determined tax pay.
Correct.
From 1/4/2017, corporation has changed over
Unit area.
from unit area. It is also prevalent probably in Delhi,
In Delhi also.
and Ahmedabad. In fact, they were They have done it earlier.
The sections are pari-material.
Yes. And we have done it later on because the scheme under the law act was not framed. Scheme was framed after the thing was proposed in 2006.
We
7.
have it from 6.
Yes. We did not implement it because it was not effective in
was-
the scheme.
Correct.
Scheme came into effect in 2017. So the whole thing started from 2017. My lord is having this brown book with your lordship. এটা আছে? এটা না থাকলে অসুবিধা হবে। একটা বই দেন আমাকে।
This is what
My lord is having it. Thank you. I'm grateful to my I'm grateful to my learned friend.
we have. I think, yes.
হ্যাঁ হ্যাঁ সুবিধে হবে।
আছে সব
হ্যাঁ সব বইয়েতেই আছে,
इसको ही
এটা
मंगा दे।
সুবিধে হবে।
इसको just requisition this one. Yes.
I told my lord's officer one day, they asked me which are the books I should bring. I told them about this book also.
They have got the latest one, but they don't have the amended one. They got the Calcutta Municipal Corporation Act. I hope this carries everything.
My lord would kindly come to after this 2017. Your lordship would kindly come to section 182 and then 182A. First, I will place 182. Then, my lord, I'd be troubling your lordship with 182A.
Yes. Yes.
My lord, this 182 section talks about submission of a return.
Yes.
Submission of return for the purpose of revision in the annual valuation of land and building to enable the municipal commissioner to revise the annual value of any land or building governed by the circumstance specified in subsection 2 of section 180, except in respect of a case under clause Roman 5 thereof, the owner or the person liable to pay property tax for such land or building shall furnish to the municipal commissioner not later than 31st day of March of the year immediately following a return in such form as may be prescribed. Malad, the law imposes a liability. There is no specific enforcement of that liability, but the liability is there to file a return so that the corporation can carry on the periodic assessments in time without any failure. So far as this assessee is concerned, no return under 182 ever filed. Now, my lord would kindly come to 182A. This is effective from
Yes.
This is effective from 1st of April 2017. Now, my lord, what does it say? After commencement of the Kolkata Municipal Corporation Amendment Act 2006, as required by the corporation, any owner of land comprising any building and vacant land or any vacant land or covered space of building or any other person liable to pay property tax or any occupier in the absence of such owner or person shall file a return of self-assessment. So it is a statutory imposition. You have to file. In the event he doesn't file, which is the case over here. Here is a case where 182A return was never filed. Now, if it is not filed, then my lord would kindly come to section 185.
Yes.
The municipal, my lord has got 185. The municipal commissioner may at any time make suo motu assessment in any case where return on the basis of self-assessment has not been filed. We have given him the notice, called for his objection. He did not react to that. We proceeded with the self-assessment and determined the valuation.
Yes.
My lord, the statement made in paragraph 13 or 14, if your lordship sees, 14 is a blatant lie. My lord would pardon me to make this statement, but the averments of paragraph 14 is a blatant lie. There is no document in support of the same. I'll just read it out to your lordship. The petitioners, through its representative, was represented before the learned hearing officer on or about, sees the language, the tenor of the language, on or about June 27, when the petitioner had placed its objection with regard to the increase of annual valuation. Absolutely a false statement. I have taken this point in my affidavit in opposition, no reply. They cannot, because it is they know it is to their knowledge it is a false statement. Now I have 14. Now, my lord, we have proceeded thereafter and determined the valuation. Then we have issued supplementary bills. Once the valuation is complete, one has to be given a supplementary bill which was not honored. Thereafter, my lord, LOI, letter of intimation regarding the dues. Once I do that, then they file this writ petition with those all specious plea that valuation is arbitrary, valuation is exorbitant, and that also is jettisoned and ultimately comes to your claim has extinguished. Now, the building had a valuation under ARV, annual rental value. That, and based on that valuation of ARV, these petitioners are paying taxes even till today. They are still paying. That valuation is around 8 lakh something. They are still paying the taxes. Now, when we the difficulty is when we compute the taxes, now, my lord, I have passed an order as I have submitted. This order has been already sent by post to the petitioner, that is Srei Infrastructure Finance. And the bills are, they have annexed the bill, supplementary bills. There is no dispute. They have given the supplementary bills from page 200 to 233. Your lordship gets the bills. শেষের দিকে হবে
233 is the notice.
Yes, my lord. Thereafter 239, 237 and onward. My lord, I cannot assist your lordship because the copy that was given to me is like this. 37. The copy which was forwarded to me is this. 37. My lord would kindly take 237 onwards.
I have.
These are the supplementary bills. So, my lord, in any count, this writ petition is firstly not maintainable. My lord, three things. They had the knowledge of the proceedings. They did not appear. They did not file any objection. And ultimately, we have decided, we have passed an order. We have sent that order by post, which is required under the law. Now, from all the angles, if your lordship sees this petition is hopelessly not maintainable at all. देखिए हमारे नोटটা दे এবার নোটটা দে নোটটা দে নোটটা দে নোটটা দে my lord, to assist my lord, yes, on 12/7/24 I have passed the order, assessment order. My lord, to assist your lordship in my most humble way, my lord, I have prepared a notes of submission which I intend to file. Whatever I have submitted before your lordship, I don't think I am supposed to give you a note of submission.
You have filed it to the court.
Yes, this is my submission, what I have filed. Your junior has taken a note of it.
তোমার নোটটা পেলে তো আরো ভালো।
No. My lord, so whatever I have argued, yes, you prepare your note, not on my basis, on basis of my note. I'll not give. As simple as that.
Yes.
My lord, now the question is, so far as the claim relating to non-payment or extinguishment, I have said, because if your lordship sees their character, they had been paying taxes. If it is a case of extinguishment of the claim, they then ought not to have paid the tax on the basis of the valuation which was existing or which was existing in terms of ARV. My lord, I cannot play fast and loose. Either I have no liability.
Even after 2017, they have been paying taxes.
Yes, till today they are paying taxes. I have got the payment records. I have got the payment records. They have been paying. I have got documents to show that they have been paying. Statement করে দিচ্ছি। না এইটা না আমার যে স্টেটমেন্ট ওটা ছাড়া your lordship sees, I do not, since it is not the part of the documents, I do not want to file, but I have got the instruction. They had been paying it on the basis of a valuation of 8 lakh, lastly 8,12,350, which is under ARV. And that tax in terms of that valuation is still being paid. আমার বাবু আমাকে যা কাগজ দিয়েছো তা হচ্ছে আমি রেডি হতে পারি, এই হচ্ছে কাগজ আমাকে দিয়েছো, দেখো দেখে নাও একবার। এই এই
আগে বললে না কেন?
আগে বলেও বা কি হতো, মামলাটা হতো না।
Yes.
229. मतलब just give me. अरे 229 is black. Yes, Malad would kindly come to page 229. He has onwards, he has given the receipt of the payments what he has made on the basis of that 8 lakh valuation. It is only to Malad procrastinate the payment, and if he is agreed, Malad, this order what I have passed upon on the basis of the ARV is appealable before the tribunal under section 189 of the Act. So if he feels he is aggrieved by the valuation order, let him go before the tribunal. My lord, those are my most respectful submission. Yes.
I give a short rejoinder, my lord.
Yes.
But I have never, the contention of the petitioner has never been extinguishment of liability as a whole. We are only saying that up to the date from the start of moratorium, initiation of CIRP, the prior period, if you have made a claim before the RP and that is included in the plan, I have the obligation to pay whatever is in the plan. If you have not made a claim at all for the period prior to the plan, it cannot come for the first time in the after I have taken over the company, after the approval of the plan. After I have taken over the company, I have an obligation to pay, which I am discharging. If your lordship kindly sees the receipts which I have annexed, this is 2024 I have paid.
That page 229.
229.
Yes.
Huh?
So what is that period in which you are alleging that no payment should be made? Because
that is the assessment notice, hearing notice which they have given. If your lordship sees, this is the period I have said, first quarter 17. First quarter 17, they are making the proposed assessment.
yes,
This is the period prior to CIRP. This is the period when the public notice was issued.
yes,
2017, this unit area assessment has come into force.
yes,
This notice, had it been issued earlier, your claim would have been filed before the RP. I would have been notified of this claim. I would have to provide for this claim in the plan.
yes.
So, but that is why I am challenging the initiation by way of the notice. When I am saying that your notice of assessment is without jurisdiction, I am not going to the merits of the order. That unit area assessment, this calculation, you have done it wrong. My learned friend is again raising the issue of appealability. I am not going to the order at all. I am saying the order is a fallout of this notice.
Yes.
Notice the authority did not have the authority to issue and determine with effect from first quarter 17. Let them issue a fresh notice with regard to unit area assessment on and after, my lord, this 2023, 11th August 2023. This is the period. On the basis of unit area assessment, I will participate in the hearing. I will give my submission, and whatever is the determination, I will have to follow. Yes, this is, my lord, the first point, the last point which has been submitted by them. Now, my lord, kindly see the question of reliefs and waivers, what my learned friend has said. My lord, I am going to seek a relief or a waiver from a demand which has crystallized into a demand at the time of the plan. I have to make a provision in the plan, or I have to seek in the plan a relief or waiver or concession from payment of any statutory debt, provided that debt is in existence at the time of the plan. Had, take for example, if this notice was already issued before the plan, and it was notified to the RP that this is the amount which has fallen due. Then when I am, my lord, propounding the plan, either I will accept that amount or I will have to apply for relief, waivers and concessions on that amount, which is there in existence. So, my lord, this amount which has now crystallized, this was never in existence at the time of the plan. Where is my question of seeking a relief or waiver? If your lordship sees the order, the paragraphs which my learned friend has placed from the order of the adjudicating authority. Yes, kindly note, my lord, the date of the notice is 4th of June 2024. So, my lord, when the plan is being propounded and approved, this demand was not there. Where is the question of seeking a relief of waiver? Now, your lordship will kindly come to that paragraph which my learned friend has placed of the order, that is at page 198.
Yes.
Paragraph 112. Relinquishment, waiver of liabilities and approvals. The reliefs Exemptions and waivers sought by the resolution applicant from the adjudicating authority are set out below for successful implementation of the resolution plan. Number one, to provide relief with respect to Central Board of Direct Taxes, to provide relief that corporate debtors shall be exempted from applicability of income tax provisions, including section 28, 41, 45, and other applicable provisions for the purpose of implementation of this resolution plan. Next one is serial number 2, provide relief to the corporate from all past litigation up to the date of implementation of this resolution plan pending at different levels, and provide waiver from all tax dues, including withholding tax, interest, penalty, and prosecution for all historic disclosed tax dues. But this was not a disclosed due before me, for me to take the benefit of waiver. So I have not sought waiver because of there is no due, there is no claim. Next, kindly see the point regarding the administrator and the entitlement to file the proceeding. Now, also one point, kindly see page 202, last serial number 17. To provide relief to the corporate debtors such that all pending litigations, notices, past and ongoing assessment and audits, past and ongoing investigation. This assessment, this demand was not ongoing.
Yes.
Yes. Now, my lord, kindly come to paragraph 118 at 223. 115 page 222. Kindly come to page 222. Yes.
Yes.
This is part of the order. We have perused the reliefs, waivers, and concessions as sought and as given in section 10 as pages 110 to 115 of the resolution plan. While some of the reliefs, waivers, and concessions sought by the resolution applicant come within the purview of the court, while many others fall under the power and jurisdiction of different government authorities and departments. This adjudicating authority has power to grant reliefs, waivers, and concessions only in relation to the code and the Companies Act. For achieving the objective of the code, no relief, waiver, and concessions that fall within the domain of other government authorities are granted. The relief, waivers, and concessions that pertain to other government authorities shall be dealt with by the respective competent authorities or semi-governments of the state or central government with regard to respective relief, waiver, and concessions. Competent authorities, including the appellate authorities, may consider grant of such relief, waivers, and concessions keeping in view of the spirit of the code. But this, what my learned friend is saying, this is not for me. It is not applicable for me. Now, kindly, what is important is also kindly see paragraph 118. With respect to, this is very important, my lord, with respect to the waivers with regard to extinguishment of claims which arose pre-CIRP and which have not been claimed are granted in terms of Ghansham Mishra. So, my lord, it is by operation of law. If you have not made the demand, if you have not made your claim before the RP on the basis of the public announcement. So then, my lord, this on the Supreme Court judgment which I had placed, my lord, is quoted here. Kindly see thereafter, on the date of approval of the resolution plan by the adjudicating authority, all such claims which are not part of the resolution plan shall stand extinguished. No person will be entitled to initiate or continue any proceedings in respect to a claim which is not part of the resolution plan. The Honorable Supreme Court also held that all dues, including statutory dues owed to central government, any state government, or any local authority, if not part of the resolution plan, shall stand extinguished, and no proceedings in respect of such dues for the period prior to date on which adjudicating authority grants its approval under Section 31 could be continued. So you don't stand on a different pedestal. All your dues are to be made part of the resolution plan, provided you make a claim. Just because, my lord, you are the government, you will not be allowed that your claims will survive even if you don't make a claim. This is, my lord, the important thing. So there is, my lord, no saving for a government authority who has not invoked their rights under the code. Now, my lord, saying this, that I am enjoying free civic services, you should not get the sympathy of the court. I am not interested to enjoy. I am saying that if you today, after the date of approval of the resolution plan, if your notice was post August 2023 under unit area assessment, I am bound to comply with it. I have never made this argument, my lord, that.
Mr. Sain, tell me one thing. How would a government agency like the corporation will get to know if a company is going through liquidation?
By way of public notice. It is for that. That is the provision.
That's right. That's what I'm asking. I'm just saying that, fine, you come up with a public notice. They are supposed to take care and they're supposed to be in the knowledge of the public notice. That's right. That is the only way they can come to know of it.
Yes.
Right? There is nothing, no letter is sent out, nothing is sent out by the RP profession.
There is no provision as such, my lord, subject to correction in the code.
And first,
That notices have to be individually sent to the claimants, which would have made the task even difficult, because actually, my lord, the purpose is there is a period within which this insolvency resolution has to be completed.
No, I'm not questioning the resolution plan or the fact that, the company is facing difficulties and all that. I'm just saying that how do we take care of?
No, I understand, my lord. I understand whether there is a system of giving individual notices or not, so that exact liability can be pinned onto them.
Public authority, a government agency is least bothered. They will not see what notices are being published. They don't even do their own work. Where's the question of following up whether a company is going in for liquidation and, a resolution?
But if they suffer once or twice because of being least bothered, then the legislature will probably make some changes or whatever. But as of now, the legislature is very clear on this. They are not to stand on a different footing. Same public notice will apply for them as well, and they have to come forward with their claims.
There's no question of notice at that stage in any event, because principal bills were paid, supplementary bills raised, still got it.
Now, kindly see, this notice itself is after the CIRP, 4th of June 2024, going back to 2017.
First quarter 2017.
But I could have understood when the unit area assessment has come into existence, they are giving a notice. They have not even invoked the amended provisions of the Act. And they will
But
collect.
in the unit area method, you are supposed to do the self-assessment. Where's the question of them coming to you or raising anything?
What stopped him from
It's
17
your,
to
it's
21?
a duty or a responsibility cast upon the assessee to file taxes.
No, that is
From 2017 onward.
That is a case of self-assessment.
This is self-assessment.
Yes, but question.
After 17, it's self-assessment.
Yes, but thereafter, the point.
12 o'clock. After what?
2 minutes.
At 12. At 12. At 12, we'll maintain silence.
Yes, that we have seen, my lord.
My question is that the self-assessment was supposed to be done by the assessee himself. So there's no question of any notice.
There is a default clause also, my lord, under section 185.
default clause is suo motu, the commissioner can always open up the assessment in case he finds anything.
Short possible. But there is a provision also for corporation to make suo motu assessment.
185.
185. Now, my lord, the question is, if there is, my lord, this does not mean that after.
No, Mr. Sen, the law seems to favor you. I'm not saying the law doesn't favor you. Law seems to favor you.
Your lordship is thinking on the point of equity. And why should, it's a question of a civic dues. But kindly consider this, my lord, I am not averse. I am not saying that I am not going to pay. I am saying.
You're saying that
2003, I have come out of CIRP. Sorry, 23, I have come out of CIRP, my lord. Let them make the assessment with effect from 23.
But what about the period 17 to 23?
I have paid also for that period on the basis of the earlier assessment.
The RV rates.
The rental value system.
Rental
value system.
Demand to the 2024.
And this, I am only questioning this demand. This revision or fresh assessment with effect from 17 on 4th June 24. I am saying that whatever whatever had been paid, I have paid. I have discharged my liability. If you thought that I have paid a lesser amount, not as per the act, you could have charged me then and there. But not where law says that the claims will go because of your default. It has now gone. You cannot take shelter under, my lord, discharging a public service. A claim in lieu of public service is also not exempted from these provisions.
But what about your responsibility under 182 or 183, where the self-assessment has to be done?
Well, it is first of all not. I'll tell you, Lordship, there has been, as I told you, Lord, there has been a change of persons coming in control. Corporate entity remains the same. Control has changed. Now the control has changed on the basis of the provisions of the new code, where the new entity in control is to take care of all past dues which they have been made aware of. Because this is a case where I am taking over past liabilities of the previous controlling authority. So I am taking charge and I am made liable for their liability as well, provided I know this is their liability. This is the thing. It is not that the code does not say that I am taking over a clean slate without anything at all. I am taking the language is I am taking over a clean slate in respect of dues which I am not been made aware of. And I don't have an opportunity to make a provision for that in the plan. That is what the
that is the saving grace. Right?
That is the saving grace. That had I known, I have to bear it, unless I get a specific waiver and concession.
Yes.
Lordship allows me one sentence. From 1721, who stopped him to file a return? So the liability of self-assessment return was conscious. It was not done. And today he says the corporation has starting to take advantage of their default. It's not my default. It is your fault. From 17
not
to
my
21.
fault. My past entity's fault.
And past entity, who are you?
No, I cannot come in. I am not. I cannot be made liable. That is 32A. Lordship will also see 32A of the code.
So that helps you.
Yes, I do not come in for past liability. And on offense also, liability for prior offense. Unless they can show that I am part of the same promoter group, which were in control of the management of the corporate debtor.
Anything else?
But I would just like to show the affidavit of competency, since the question of authority has been said.
Yes.
There is a resolution affidavit file. Kindly have a look at that one.
Administrator has been discharged.
Kindly see, my lord, I have annexed here.
Yes.
Resolution of the 263 meeting of the board of directors of the company held on such and such. First paragraph, it was informed to the board that pursuant to order of the Honorable NCLT dated such and such approving the resolution plan submitted by resolution implementation and monitoring committee was formed. Administrator stroke chairman of the interim monitoring committee implementer had issued several authorizations. POAs, conduct of the business. Further, since the IMC stood dissolved in terms of section 6 of the approved resolution plan, the board discussed the matter at length and ratified the following. The existing POAs authorizations issued by the erstwhile administrator stroke chairman of the implementation monitoring committee. Board discussed the matter in detail and unanimously passed the following resolution. That in supersession of all earlier resolution, the following power of attorney stroke authorization issued by the administrator chairman of implementation monitoring committee be and hereby ratified, and any POA or authorization issued not included in the following list stands cancelled.
My power of attorney is here.
Now my power of attorney is given here, my lord.
Sohan Jha.
Kindly come to serial number 9. Legal matters, Sohan Kumar Jha, who is the petitioner number 2 here.
And
And the power of attorney is also annexed at just the first annexure. Kindly see, now know this present witness, Mr. Rajneesh Sharma, the principal advisor to be hereby in exercise of powers vested upon him, is empowering and authorizing Sohan Kumar Jha, manager, by this power of it to execute on behalf of the company the following acts, these matters and things are enumerated herein with below relating to legal matters of the company within territorial limits of India. So, this is based on this resolution. Why this is filed in court at the time of filing the writ petition? Otherwise the writ petition will not be filed at all.
So that's fine. This will do.
And my lord, kindly see the administrator paragraph 128 of that order, page 225. Administrator has been discharged by this order.
The IMC came.
And replaced by the implementation and monitoring committee. Administrator shall stand discharged from his duties with effect from the date of this order, 7 except the duties envisaged in the resolution plan as part of the implementation and monitoring committee.
Yes.
Now, the successful resolution applicant is also not a private individual. It is a consortium of banks. PSU banks, public sector banks, my lord. NARCL, my lord. That I have also stated in my petition.
Paragraph 6.
Yes. Well, I think these are my submissions.
All right. CAV.
But I have made a refund in terms of I have made a deposit in terms of the interim order. Subject to what order your lordship will pass, my lord?
Supplementary bills.
This. And one more important thing, my lord. I have challenged every action on the basis of those hearing notice.
Order.
So bills are a consequence of that hearing notice.
Prayer B.
Prayer B, your lordship will see in the writ petition. Well,
Yes.
this and also, my lord, kindly take on record in terms of the interim order, the deposit was made of rupees 35 lakhs, which is held by the corporation, my lord.
Which I'm seeking refund.
Yes.
If your lordship permits, will I file a 2-page note?
By
Next week, my lord.
I want
কবে
to
ফাইল করতে পারবে? আচ্ছা, Monday they will file.
Monday. Learned counsel for the petitioner is granted liberty to file a written argument not exceeding more than. You have already filed.
I have filed mine.
Yes, learned counsel for the respondent has filed
So I could not.
his notes of written argument. The same is taken on record. Full stop. You want to file something else, Mr. I'll give.
This is only this. This was not there. I find that the board of directors of the company
Yes.
has given this.
So I can give you time till Monday. If you want to file your written submission,
Very well. I'll
parties are directed to file their brief written argument
I'm taking a copy.
not exceeding more than 4 pages by Monday. By Monday, you file it, then we'll pass it on. ये ठीक से रखना मुझे भिजवा CAV. CAV.
করে দাও
Judgments वैसी में रहने देना. And Mr. Sen, if you can, both the parties, if you can put in along with authorities to be relied upon, brief written
Yes, I will annex the
along with authorities which they wish to rely upon by Monday.
No, I have not.
No, he has not cited it.
I have accepted those propositions.
He has not cited it. By Monday, rely upon.
All right.
I'll take a 2-minute break.
Item number 8.
Lordship, in this matter, your Lordship was pleased to direct the petitioner to file a exception, your Lordship, but that could not be filed, your Lordship. I am praying for 2 weeks of extension to file that, your Lordship.
My lord, I am appealing for the corporation, my lord. Corporation has already filed a report, my lord.
Lordship, only 2.
Corporation's reply is there, no? Learned counsel for the petitioner seeks further time of 2 weeks to file his exception to the report filed by the respondent. Full stop. Liberty is granted. Let this matter appear after 2 weeks. Let me do this.
Item number 9.
My lord, in this matter, my lord, your lordship, last occasion, proxy counsel appears and took time. And I am on the impression I appeared along with my junior. And actually expected a copy. I called him several times. But they are supplying.
My lord, the copy has been served, my lord. My lord, in this matter, my lord, I seek 1 week adjournment, my lord. Due to, my lord, the service on the private respondent is not complete, my lord. As a last chance, my lord, kindly adjourns this matter to next week, my lord.
What is happening? Why are you avoiding it?
My lord, the application is in relation to mutation given to the private respondent, my lord, illegally. That is the application before your lordship, my lord, today. However, my lord, the service upon the private respondent who are necessary parties in the writ petition is not complete due to the want of their address. We have attempted service, but the service couldn't be complete. However, my lord, this week we have initiated fresh service, which is to be complete, my lord. Therefore, my lord, kindly grants me 1 week, my lord. I shall come back, my lord.
Learned counsel for the petitioner states that he has not been able to serve upon the private respondents. Learned counsel for the petitioner states that he has not been able to serve upon the private respondents. Full stop. He seeks further 2 weeks time to effect service on the private respondents. Full stop. Mr. Das, who appears for the respondent corporation, respondent corporation, states that he has not been given a copy of the writ petition. Full stop. Petitioner is directed to supply a copy of the same during the course of the day. Full stop. Let this matter be listed after 2 weeks.
I'm grateful.
Supply him a copy.
My lord, the copy.
আমি আমাকে একটা কপি দিতে বলছি জয়সনা বলছে দিচ্ছ না কেন বিষয়টা
Item number 10.
My lord, I am for the petitioner, my lord, unauthorized construction, my lord, and the second round litigation, your lordship. And my lord, kindly see the last order, your lordship, they are supposed to file the report.
I'm for the KMC lordship, led by Mr. Shopondel. Yes, my report lordship.
May I get one copy, my lord?
পরে দিচ্ছি, একটাই আছে।
ছবি তুলে নিচ্ছি। এবার ছবিটা তুলে রাখি আছে।
Happy page.
If there is no stay, from the tribunal.
That's the question, madam. They have not obtained any stay. The person who
demolished?
has against, I am for the Kolkata Municipal Corporation.
Yes.
I am leading him. My lord, the person has been, my lord, kindly come to at page 12. The order has been passed against the Khurshid Alam. Page 12.
Yes.
And demolition order has been passed. And statute provides for an appeal. And there they should have filed an appeal stay application, but they have not yet filed or they have not obtained it. That instruction I have not. But they have filed a BT appeal. That is pending before the BT building tribunal. But there is a building.
That's right. So
therefore, my lord, if it is not, if my lord, but that may be directed to dispose of appeal.
why should that?
And my lord, kindly.
What kind of arguments are you making?
Kindly,
What
400,
take?
405 stipulates for granting a stay. Otherwise, the appeal will be infructuous.
Appeal will not be infructuous if a stay has not been granted. You are at liberty to demolish the property.
Yes, that's right. That's right. That's
So
right.
go ahead and do it.
As your lordship. As your lordship. As your lordship.
It's not about this court wishing. It's your duty cast upon you. This is your statutory duty to carry out demolition if there is any unauthorized construction. Just by merely somebody filing and going to the tribunal doesn't hold your hands.
That is right. That I am not denying. That is I am not denying. That is not. But
then why you have not filed a report of action taken?
No further action.
Why you have not filed a report with the action taken, compliance report? Why this kind of a cryptic report which you have filed?
My lord was pleased to what is the position that has to be brought before your lordship.
So the position is that you should comply with the orders passed by this court, which you are not doing.
Sometime maybe given, I complain.
Don't make frivolous arguments. We are not sitting here to understand your knowledge of law. Take down. A report has been filed. The executive engineer building, Borough 9, has completely failed to carry out the orders of this court. Full stop. The report indicates that a demolition order has been passed for the unauthorized construction, which is beyond the sanction plan. The executive engineer seems to be hand in glove with the respondent. The private respondent, right?
The respondent number, my lord, 327.
With the private respondent number 327, wherein he has stated in the report that since the private respondents have approached the building tribunal in BT case number 71 of 2024, the department is awaiting the final order from the municipal building tribunal. Full stop. It seems the executive engineer is not competent to perform the duties of his office, since there is no stay granted by the building tribunal in BT case number 71 of 2024. The department is at liberty to carry out the unauthorized construction in terms of their demolition order, which has been passed. Full stop. To take a plea that the matter is pending before the building tribunal only reflects that the executive engineer is not willing to carry out the orders of this court and even to act upon his own order of demolition. It seems that officers who fail to understand their own orders shall not be officiating in the building department. Full stop. A copy of this order shall be communicated to the Commissioner, Calcutta Municipal Corporation, to take appropriate action in educating the executive engineer that if there is no stay granted by the building tribunal, he is at liberty to carry out the orders of demolition. Full stop.
And my lord,
With the
DG
above
will-
direction,
my lord, Director General of the building may be directed. So,
Commissioner should be directed. Let a copy of this order be communicated to the Commissioner. A compliance report shall be filed within a period of 2 weeks thereafter.
my lord,
Nothing, my lord.
Nothing
Yes, my lord.
my lord, within 2 weeks, my lord, 4 weeks may be given.
within 4 weeks. Suspend the officer. A copy of the report is kept on record.
I am grateful, Your Lordship.
You should carry out proceedings against these kind of officers.
My lord, that's-
And you are trying to take a ground.
I am not, my lord,
Being an officer of the court,
in
you are trying
usual
to shield
course-
these people.
No, no, in usual course of business of the Kolkata Municipal Corporation, they are sometimes wait for the order of the tribunal, but they should not.
Sir, you are a lawyer.
Something.
You represent
Yes, my lord.
Calcutta Municipal Corporation. Do not make this kind of submission.
No, my lord, I am not 45.
You are supposed to educate them.
Sir.
This is your duty.
I am grateful, Your Lordship.
Master,
Item number 11. 11, Lordship, I beg to appear on behalf of the petitioner.
Yes.
Lord, this is a second round of litigation. Myself is a flat owner of 26 Shakespeare Surrounding within the city of Calcutta. Well, there are a number of other flats, but SSC number is 1. As a result of which entire tax burden, my lord, as if I am liable to pay taxes. My lord, the corporation, my lord, the thing is this, there are provision. If someone is found in occupation, corporation can show moto, my lord, assess the property in favor of other persons also. Be that as it may, my lord. This is second round of litigation. I am drawing lordship attention, page 31.
You have seen the last order.
Yes, my lord.
You were supposed to take instruction whether you want to go to the municipal valuation.
My lord, last order,
No.
so far subsequent developments are there. My lord, in spite of specific direction of the Honorable Reed Court, my lord, they failed to, my lord, adjudicate my representation. And even if it was adjudicated previously, there was no such communication. As a result of which we have filed this.
Show me.
I am showing, my lord. Lordship, kindly come to page 31. Page 31, my lord. I am reading only relevant portion. That is page 32A, internal page 3. Lordship, got it?
Yes.
Second paragraph. Accordingly, this court is of the view that the corporation has stated that the petitioner may write to the assessor collector or appear before the authority with a document in support of her contention. The writ petition should be disposed of with a direction upon the assessor collector to dispose of the representation of the petitioner, which is at page 32 of the writ petition, in accordance with law, upon affording an opportunity of hearing to the petitioner. The petitioner shall be allowed to produce all documents in support of her contention, and the prayer of the petitioner for adjustment of the amount lying in the suspend account must be considered, A reasonable order shall be passed and communicated to the petitioner. Well, that being the direction, and that to be done within 2 months from the date of the order. My lord, next paragraph, entire exercise shall be concluded within 2 months. Then what happened, my lord? In spite of this particular, my lord, the observation made by the Honorable Reed Court, my lord, they have taken it very casually. And then, my lord, page 35 may kindly be looked into. My lord, there was a tenant. Previously, it was Syndicate Bank. Now it is merged with the Canada Bank. Now it is Canada Bank. My lord, they have attached rent for realization of taxes in terms of section 225 of the Calcutta Municipal Corporation Act. My lord, date may kindly be looked into 12/11/2024. Rather after 2 years, my lord. Page 36 may kindly be looked into. Next page, my lord. It is the letter of the municipal commissioner addressed to, my lord, the owner of the writ petitioner herein, that
failed to discharge your duties. Once so, though I have deposited, my lord, substantial amount, my lord, paragraph 2 may kindly be looked into. On the one hand, my lord, they have attached the rent from the tenant. The other hand, my lord, it is further ordered that property specified in the schedule hereunto annexed will be sold unless the amount of tax due with all cost of recovery is paid into the corporation office so and so. So, my lord, they have started a realization process, and realization process they have attached rent. Lordship knows, my lord, the bank people used to, my lord, make higher rent. On the other hand, at the same time, my lord, they have decided to sell it out. So, my lord, the realization of tax is their only duty. They are trying it, my lord, double jeopardy at the same time. Then, my lord, I wrote a letter addressed to them. I am 70 years old, and this particular rent is my only way of my survival. That is page 37, 38. Here, my lord, lordship will find 38, last two paragraph. I am presently aged about 72 years and has been suffering from various ailments and most unable to move smoothly and freely alone. I have lost my only issue, my lord, my son, leaving behind me his widow and so and so. And the rent which I have been realizing in only the source of my income and livelihood for me and other members of my family as well. Consequent to the above, I beseech your good office to consider my prayer favorably. Now, my lord, what happened when I have filed this writ application? Lordship will find from page number in the month of December 2024, after receiving the notice, 13th day of December, page 29, 2024. After receiving this notice, my lord, they have, my lord, sent a letter addressed to me. Letter says, meet us immediately for hearing and produce all the document, including the direction issued by the Honorable Writ Court previously, to consider page number 32 of writ petition. Lordship, this is the letter. This was issued in the month of January 2025. And subsequently, they have handed over a copy of order, which was, my lord, purportedly passed in the year 2022. And, my lord, without considering, my lord, the direction issued by this honorable court, as a result of which some subsequent developments are taken place. That is why we intend to place a supplementary affidavit. Lordship was reluctant to some extent, but our humble submission, my lord, they cannot attach my rent. I have paid my taxes. Huge amount has been paid, that has been recorded by the Kolkata Honorable Writ Court. That is, my lord, lordship will find from the order of the Honorable Writ Court, demanding 5 crore for a 2580 square feet. Demanding 5 crore for 2580 square feet. I don't know, my lord, whether, my lord, the sale value is 5 crore, my lord. In the event it is sold out, my lord, possibly, my lord, the total area will not be realized by the Kolkata Municipal Corporation. My lord, the thing is that there are number of other flat owners. SSC number is 1. Apportionment has not been made, as a result of which huge liability. Now, my lord, in this situation, my lord, this particular letter was issued. May I be permitted to hand over this letter, my lord? Kindly see. They have requested us to produce all the document of previous writ application, including our representation. If the order was passed in the year 2022, what prompted them, my lord, to write this letter? I put this question to myself.
The representation and consider subsequently they have wrote this. And December, after the issuance of this. January 25.
Yes, Mr. Mukherjee.
But no copy of order has been supplied, nothing of this sort. And, my lord, our humble submission, in the event they have sent it by, my lord, the certificate of posting, under certificate of posting.
Where is that assessment order which has been passed?
My lord, that was not been enclosed, that was not is available with us. They did not supply us assessment order.
So you have only been given this attachment, notice of rent.
Rent of attachment. My lord, that is page 35. On the one hand, rent attachment. On the other hand, they have decided to sell it out. And tenant is, my lord, taking a plea. They are going to leave this particular premises. They do their business, my lord, in a peaceful manner and way. And I am a 72 years old, lost my son, as a result of which
Yes,
that.
Mr. Mukherjee.
My lord, would kindly come to page 31.
No, but what is the point of issuing this letter in 2025?
Well, the question is, the assessment done.
Why the assessment was done
It was
without
crystallized
giving
into a demand. Demand was not paid, and ultimately all these representations are coming. Now, my lord, would see the last representation. What does he say? Is there any challenge to the valuation? My learned friend is infusing the valuation part. It is not there anywhere in his letter. is simple letter that my son has died, my husband is gone.
Give me
Now
the
I am
breakup. Give me the breakup.
I am living over there. It is my only source of bread and butter. Give me the breakup. If your lordship kindly sees page 38 middle, 37, 38. I call upon you, paragraph 8 at page 38.
Just a minute, Mr.
Lordship.
Sorry, what's your name?
Mr.
Mr. Chakravarti.
Let's.
Mr. Chakravarti. Mr. Chakravarti, please have a look at the judgment on page 31 first.
Yes, my lord, I am.
The first paragraph.
My lord, internal page 2.
First paragraph.
First paragraph. Where petitioner has alleged inaction on the part of assessor collector in disposing of the representation of the petitioner, which is at page 32 of the writ petition, and a part of annexure P4. It is the contention of the petitioner that the letter of intimation issued in the month of December 13, 2021, demanding 5,18,18,756, including interest and penalty, should be adjusted with the amount lying in the suspense account of the corporation. It is further submitted that the letter of intimation clearly provides an opportunity of the petitioner either to send a letter by post of the assessor collector or appear physically with document in support of the petitioner contention that the contents of the letter of intimation are not correct. According to Mr. Jaydeep Kaur, learned senior advocate, the letter of petitioner, which appears in page number 32 of the writ petition, which was sent by registered post, was issued in terms of the opportunity granted in the letter of intimation. Mr. So-and-so, my lord, learned advocate appearing on behalf of the corporation, submits that the letter had just been sent and the authority did not get any adequate time to deal with the same. Mr. Mukherjee further submit as the payment have been made intermittently. My lord, I have made payment. The interest had gone up, and the calculation of the amount payable in the letter of intimation was based on interest and penalty payable by the petitioner. Having considered the record, it appears a huge amount over 1 crore is lying in the suspense account. Not that I am not paying. I have paid for 2580 square feet with the Kolkata Municipal Corporation. In the letter of intimation, the petitioner has also been given an opportunity by the Municipal Commission at Kolkata.
All these letters, Mr. Chakravarti, has not really taken care of the demand.
Yes.
The demand which has been raised by them, where have you challenged that demand?
Yes, my lord. That being
have you challenged?
No, my lord, the thing is this, my representation, which was in the page 31 of the previous writ application, was not adjudicated. As a result of which, in the month of January 2025, they have invited us to produce all the relevant document, including annexure P4, page 31, before the authority. Though they have taken a stand, they have passed order pursuant to the direction of the Honorable Justice Shampar Sarkar in the month of, in the year 2022. Our humble submission, no communication has been made. Had it been, my lord, communicated, there would not have any occasion to invite us to meet them in the month of January 2025. When the adjudication is pending, they cannot issue a notice under section 225 for rent attachment on the one hand. On the other hand, my lord, they have decided to sell out my property. So that being the situation, my lord. My lord, myself may kindly be protected, my lord, subject to correction. I am beseeching, I am an old lady. At the same time, hearing may afresh to be given by the Kolkata Municipal Corporation. And my lord, apportionment is required to be made. Apportionment can be made suo motu also. Other flat owners are also there. Had it been apportioned in appropriate manner, my liability would be reduced. My lord, all are not aware about the KMC law and all these things. My lord, that being the situation, she is an old lady, lost his son, and the same time, meanwhile, lost his husband also, her husband also. This is my humble submission.
Yes, Mr. Mukherjee.
My powers are distinct. One is relating to the attachment of
so, but Mr. Mukherjee, the first and foremost is, why didn't you give her a hearing when an order has been passed earlier?
Later, what my learned friend has handed up. If your lordship sees, I should take it.
Yes, give a copy.
My lord, kindly seize that letter.
You see that?
Yes. My lord, on 7th of January, this was issued. Your lordship sees the last paragraph. If that is the one what is troubling my lord, with the deepest of respect and utmost humility, I submit. My lord would direct them to go in terms of that letter.
Yes.
Till then, hold your hands.
Till then, my lord, so far as the rent attachment, that continues. Rest of it, I am holding my hands. I am holding my hands.
My only way of my survival, my rent cannot be attached. I have deposited 1 crore to their credit. That is recorded in page number 31. For 2580 square feet flat, I have deposited 1 crore.
On 20th of January, she was called at 3 p.m. Now, my learned friend's junior who was appearing, she said that she was not keeping well. And that's the reason why the time was taken.
My lord, a phrase state may kindly be fixed, my lord. Notice may kindly be dispensed. We'll go there. And my lord, including rent attachment may kindly be.
Your lordship says that
Ultimate date for.
Rent attachment you state.
the rent attachment is one part, that is a power under
Till you,
55.
till you,
Now, my lord, auction sale is a different power under a different act, as it has fallen from my lord. The rent attachment, I am submitting this subject to the approval of your lordship. Let the rent attachment go there. I am standing my hands off so far as that attachment
Sale part.
auction part is concerned. Let her go for an hearing, either herself or by through a representative, and we will hear and pass an order.
We are beseeching, my lord, unless, my lord, the adjudication is properly made in terms of the previous judgment, my lord, they cannot do all this.
rent has already been attached, sir, before. Mr. Chakravarti,
Presupposing now,
I'm praying, my lord,
just
he
because I am
attached it.
leaving some
Otherwise, my
ground,
survival is at stake.
just
Only
because I am
among-
leaving some ground,
only-
he is now
rent attachment,
extending his.
Not
rent
that-
attachment will continue.
my lord, true, my lord, not that I am not paid. I have paid 1 crore.
That's all right, Mr. Chakravarti. Rent attachment,
How do I survive, my lord? Kindly consider.
they will pass an order.
For the time being, for
They
the
will-
time being. One
not
or
for
2
the-
months, my lord, meanwhile, they will decide.
The problem is, once an order is passed by this court, this continues in perpetuity.
That being the situation.
I am
Otherwise, my
not for rent attachment. Just take down.
prayer is, my lord, the attachment.
Learned counsel for the present writ petition has been filed. Seeking stay of setting aside and quashing of notice dated notice for rent attachment dated 12/11/2024 and order of attachment of immovable property dated. What is the date of this? This attachment date?
12th of November 24.
12/11/2024. Full stop. These are your two prayers, right? Learned counsel for the petitioner states that this is the second round of litigation. Learned counsel for the petitioner states that he had earlier preferred a WPO number 809 of 2022, wherein a direction was passed by this court on 9th February 2022, directing the corporation, directing the assessor collector South to dispose of the representation of the petitioner, which was attached at page 32 of the writ petition, in accordance with law, upon affording an opportunity of hearing to the petitioner. The exercise was to be completed within a period of 2 months from the date of communication of this order. Full stop. Petitioner contends that he did not receive any intimation for hearing. Full stop. And there was no adjudication in terms of the earlier order passed in the writ petition. Full stop. He states that he has received the notices dated 12/11/2024 and 22/11/2024 in contravention to the directions passed by this court in the earlier round of litigation. Full stop. He further states that on 7th of January 2025, he had, after a lapse of 2 years from the date of the passing of an earlier order in writ petition number WPO number 809 of 2022, dated 9th February 2022, he has received a notice of hearing on 7/1/2025, directing him to appear before the Assessor Collector South, Calcutta Municipal Corporation on 9th February 2022. Full stop. He alleges that without affording an opportunity of hearing and without deciding his representation in terms of the earlier order passed by this court on 9th February 2022, the respondent KMC could not have passed the notice of rent attachment dated 12/11/2024 and the order of attachment of immovable property under section 212A2 of the Calcutta Municipal Corporation on 22nd day of November 24. Full stop. Learned counsel for the respondent KMC, Mr. Mukherjee, very fairly states that they are ready and willing to give a hearing to the petitioner and that the notice of attachment of immovable property under section 212A2 of the Calcutta Municipal Corporation shall not be given effect to till the petitioner is heard and a final adjudication and appropriation of property tax vis-a-vis her share in the property is decided and a final order is passed on her earlier representation as directed by this court on 9th February 2022. Full stop. So I am already, that will not be given effect to, the rest can carry on with the above.
Attachment part.
Attachment,
Yes,
auction.
my lord, attachment of rent is already
Not attachment of rent.
Only
the
auction, sir.
auction part.
Auction.
That your lordship clarifies that
I
your
have-
lordship is interfering only that auction.
Only auction. In the meantime, this court is only, I've stated so. Mr. Mukherjee has stated that you will not be giving effect to the order of attachment
Yes, that your lordship says.
dated 22nd November 2024. With the above direction, the presented petition is,
Question, at least a portion is required to be taken.
I said that. A portion.
The portion of rate is required to be, my lord.
They will apportion that. They will, sir, let them apportion that. And then whatever it is, yes. So I've already said that during the course of the hearing, they will pass a final order whereby the apportionment will be done as far as your property is concerned.
What your lordship is the one apportionment, what your lordship, my lord, with the deepest of respect, again I say, apportionment your lordship is referring to, that will, what is submitted, there are 6 flats. Each flat in a building has an apportioned share to the tax. This will lead to that apportionment of tax.
Yes.
What he is seeking, if he is getting 50,000 rupees of rent, we have attached the entire 50,000 of the rent. He now seeks that kindly give me 5,000 out of that 50,000 and keep 45,000 with you.
Or my
This is his
That won't,
sense of apportionment.
that won't be possible.
Yes.
My lord, I'm for the bank, my lord. My lord, let me participate in the hearing since I'm in the occupation.
The petitioner, jahan hearing diya hai na, shall be given a hearing along with all the interested parties, including the bank.
Great.
Assessment is only in respect to
And the disposal to be
With the-
department ke jharu.
Otherwise,
The-
once again, I'm come here.
The parties, the petitioner, as well as the interested party, including the bank, shall appear before the assessor and collector South on, give me a date.
My lord fixes a date any day
Tell
after
me.
3 weeks.
After 3 weeks, which date you want, Mr. Chakravarti?
Because all these holidays are,
When do you want? Give me a date, Mr. Chakravarti. Look at your calendar.
That will be ultimate day for everything.
After 3 weeks, Thursday, 10th of April,
yes,
shall appear before the
10th
assessor.
of May it would be.
10th of May. Before,
ছুটি আছে না?
no, 10th May, Saturday. 14th of May. 14th of May. Before the assessor and collector south on 14th of May at 3 p.m. in his chamber
5 years and
situated at CMO building, first floor, room number 130, 5 SN Banerjee Road, Calcutta. Full stop. The final, after affording an opportunity of hearing, it is expected of the assessor and collector, right? Assessor and collector south, that a final speaking order shall be passed within a period of 8 weeks thereafter. Full stop.
Subsequent developments are there. Fresh representation may not kindly be permitted to place before the order.
That is all.
When you go there, go and give everything document.
That will be ultimate.
Take
one
the
and
plea,
only
those
hearing
things
date.
there. I will not. One line may kindly be given. Subsequent developments are there.
Then it will change the entire scope of the writ.
scope of consideration.
With the above direction, the present writ petition is disposed of.
Item number 12.
Well, my lord, I beg to appear on behalf of the petitioner. Lordship, here also, my lord, no hearing, no copy of notice has been supplied to us. Realization process they have started, demanding huge amount. On one occasion, I went there, my lord, to deposit certain amount. Lordship, kindly come to page 59. 20 lakhs. On that particular date, I was there to deposit 20 lakhs. Annexure P4, page 59. Lordship, got it?
Just a minute.
Para 2.
Just a minute.
Today on so-and-so, I have submitted two number of demand of total amount rupees so-and-so, 20 lakhs 95,000 against the total outstanding due in respect of
You
5
have deposited the money, right?
Lordship.
You have deposited the money.
Yes, my lord.
Yes.
Deposited the money.
Yes.
Then, my lord, what happened?
Mr. Chakravarti, where are you?
Kindly see, my lord.
Which
Next
page? Which page? Which page, Mr. Chakravarti? Which?
page 59, annexure P4. Annexure P4.
Yes.
Second paragraph, I have deposited that amount. Beside this, I hereby undertake to pay the rest of amount in respect of that.
I am slightly slow, so just go slow.
Lordship.
Yes. Yes, read now.
Then, my lord, third paragraph, they have taken one undertaking, forced me to do this undertaking. And the last line of, my lord, that particular paragraph, failing which KMC authority shall be free to take necessary action as per KMC Act 1980. My self-incrimination, I was forced to do that. Then, my lord, thereby, I hereby request you to kindly withdraw the distress warrant today and give me opportunity to clear the outstanding tax due as per the above schedule. No matter our humble submission, we have challenged before this honorable court. This undertaking, there is no provision in the four corner of the Kolkata Municipal Corporation Act to take any undertaking. Supposing, my lord, if lordship kindly permit me, I can show, my lord, in the building rules there are provision to give undertaking. Supposing I am doing one construction in a particular place, I am to undertake before the Kolkata Municipal Corporation. In the event I damage my neighboring premises, I shall remain liable to pay, my lord, the damages, compensation and all these things. That particular, my lord, the undertaking is recorded in the rules in the four corner of the Kolkata Municipal Corporation Act. That is not there. Our humble submission so far undertaking is concerned, the statutory authority cannot do anything unless it is provided by the law. Common man can do, my lord, unless it is prohibited by the law. Then, my lord, lordship kindly see, this is first bold, my lord, my submission. Then, my lord, there was direction for, my lord, exchange of affidavit. In exchange of affidavit, Kolkata Municipal Corporation, my lord, divulged certain document which is interesting. Lordship, kindly come to there. Kindly come to your affidavit in opposition.
But why have you come here?
My lord, because, my lord, the procedural.
We are not experts in this.
No, my lord, the procedure, the decision taken by them, only one document, my lord, kindly see why we are here. Why we are here, lordship will find, my lord. Subject to correction, my lord. Page 13. of their affidavit.
13.
13.
Yes.
This is the inspection book maintained by the Kolkata Municipal Corporation. Right hand side, my lord, the previous valuation.
Yes.
Left hand side, my lord, lordship will find the proposal. Lordship will find, my lord, no signature, nothing of this kind. All blank. All blank. Annual valuation is a stamp. No application of mind. They have their own stamp and huge valuation they have decided in this fashion. Page 13. Annual valuation is revised under section 180 subsection 2 Roman 9. What is there, my lord? Lordship knows, my lord, the general revaluation is commenced after 6 years. In the meantime, if intermediate valuation is required, intermediate valuation may be made. Supposing, my lord, change of tenancy in annual rateable value system, a particular, my lord, the floor has been demolished on the verge of an earthquake. It is a good ground for, my lord, the intermediate valuation. 180 is that particular section of intermediate valuation. 180, my lord, subsection 2 Roman 9 may kindly be looked into, my lord. May I hand over a copy of the book, my lord?
So on page 13, what are you trying to show, Mr.?
My lord, I am trying to show the valuation is yet to assume finality. On the basis of that, my lord, they are trying to raise their demand and realization process.
How do you come to that finding?
Kindly see, my lord, that is the signature is not there, all are vacant. Blank, kindly see, my lord.
Nothing called fixed.
Here, my lord, 13, type of property, blank, 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 total area, blank, blank, blank. Then, my lord, stamp, they have put the stamp on the body of the inspection book, and at the bottom, my lord, decision of hearing officer in terms of section 188. We are not aware. That is a separate, my lord, the seat is required to be, my lord, used for that purpose, and a copy of which to be supplied in terms of the mandate of the law. That was not supplied, never supplied. Acceptance by RO, PLPT, person liable to pay taxes, it means PLPT. Occupier, photo ID number, every column is there.
The officer's signature is not there.
It is blank. That being the situation. Now, lordship, kindly see more document. Next page. Notice, page 14.
Yes.
Page 14 at the top, lordship will find self-assessment. Lordship knows what is that is area-based taxation.
Yes.
SAF, self-assessment form suo motu registration at the top. Kindly come the mailing address, thereafter premises number, then, my lord, come to the box. In box, my lord, first entry, ARV, annual rateable value. So at the same breath, both are not permissible. Whether it is ARV valuation, notional rent to be, my lord, find out, or, my lord, the self-assessment, or, my lord, the area-based taxation.
ARV is before 2017. 1st
Yes.
of April 2017.
Yes, my lord.
Your unit area comes into effect.
Subsequently,
This
but
is
though at the top,
2016.
yes, my lord. 4th quarter 2016.
ARV is fine as far as this is
My lord,
concerned.
the 2017 new act promulgated. And 4th quarter 2016 means in terms of section 179. Just a minute, my lord, I may be allowed. 4th quarter means, my lord, shall have effect from the beginning of the quarter of a year ending 30th June, 1st quarter, 30th September, 2nd quarter, 30th December, 3rd quarter, 31st March. 4th quarter means, my lord, March 2017. In terms of section 1.
March 2017, the act itself has not come.
March.
Is it prospective? Are you trying to say that it is retrospective?
No, my lord, so far the act
Is it
is
prospective or retrospective?
It is prospective.
If it is prospective, it comes from effect only from 1st
True,
of
my lord,
April
there is
2017,
true,
sir.
true, and there is
So the
defect in
period
that
which you're talking about, the ARV is to be assessed.
ARV to be assessed.
After that only it is going to be unit area method.
Unit area, though their form is to some extent defective. That is what I'm trying to show the lordship. That being the situation. Then, my lord, kindly see next page. My lord, they are trying to show certain documents from which they are trying to establish. They have sent us notice. My lord, the deeming provision.
4th quarter 16. This is for 4th quarter 16.
Lordship, one more. I'm grateful to my learned friend. Kindly see, my lord, page 13 once again. Once again, my lord.
Your friend assists everyone very well.
Grateful, my lord. My lord, 13, page 13, 4th quarter 2016-17. At the my lord, the corner. Lordship will find. At the corner. That is why that confusion was arose, because of they have used area-based taxation form. At the same time, in column, they have written ARV. Fourth quarter 2016-17. Be that as it may, my lord, what I am trying to show, my lord, kindly come to my lord.
Read down, read there only, page 13.
Yes, my lord.
The clarity is there. Annual value on the right-hand side.
Right.
Annual value is revised under section 182, read with 174, as stood prior to commencement of the unit area assessment scheme with effect from 1/4/2017. So the existing AV is this is proposed AV is this. So there's no discrepancy as far as this is concerned.
Then, my lord,
I can take your argument for the fact that yes, there are no signatures, no application of mine. That I can still understand that argument. But beyond that, I don't understand anything else.
my lord, kindly see, my lord, the particular provision of intermediate valuation as they have used.
Yes.
180 subsection, my lord, 2 Roman 9. Lordship, kindly, my lord, they examine that provision. Section 180 may kindly be looked into.
Let's see. Oh, let's see after lunch.
So, my lord, at 2 p.m., my lord, 2-3, my lord, appellate side matters are there.
After that, we'll take this.
After that.
Your lordship permits, my lord. A very extraordinary
No,
circumstance.
I will not permit, sir.
No, my lord, this matter pertains to Port Blair, my lord. I had mentioned the matter before Honorable Justice, before the Chief Justice, my lord. The record has come. The office, my lord, directed me to mention it before your lordship.
We'll have it on Monday.
Because no, my lord, my interim order will be expiring tomorrow, my lord. That was the urgency, and it was considered by Honorable Chief Justice, my lord. The soft
Tomorrow.
copy has come to this court, my
Keep
lord.
it for tomorrow.
Yes, my lord. I'm placing.
Keep it for tomorrow. Send the file to me.
Grateful. Grateful.
Send the files. Keep it for tomorrow.
Grateful.
We'll have it after lunch. This one we'll have it after. After we finish those 3 matters, Mr. Chakravarti.
Grateful, my lord.
May I have a list kindly, Lordship, to mention one matter, Lordship, item number 45, Lordship, it is that auction matter, bank auction matter, Lordship, if kindly takes it up at 3 p.m. Lordship today. It is there is
Not
some,
possible today, madam.
there is some urgency in the matter, Lordship.
I've got these three matters and then I've kept a matter which I was hearing before lunch. Not today.
Kindly keeps it then tomorrow, Lordship, there is
This is
some-
item 45 in which list?
today's list, Lordship, original side,
Original side?
45, Lordship.
I don't think so we can reach till there. Not today, madam.
Lordship,
So far as item number 46 is concerned, I believe both were mentioned and your lordship was gracious enough to place it today on the board. There is some urgency because if the sale certificate issues, the sale is crystallized or a third party right is created, then we will be aggrieved.
I can't
That
hear
is
it.
the only issue. I don't want to labor upon your lordship as it
Won't be
comments.
possible, sir. Won't be possible. I have to hear these matters.
Lordship, may I renew, item number 45, renew my prayer at 3 o'clock, Lordship, will I again take up original side matters from 3 p.m. as per.
Let's see.
Lordship list?
Let's see.
May I-
I'm bored.
Very well. We'll come back
Deep
actually.
Lordship, deep Lordship.
Very deep.
But I am challenging the tender.
Yes.
Happy to say it.
Just a minute.
Item,
Sorry.
item number 1,
And three, both.
Appearing for one of the oil companies. Three oil companies are there.
I'm representing HP, sir.
Yes.
But will kindly come to page 42. Okay.
The
If your lordships kindly come to page 42, that means tenders are invited under two-bid system for bona fide bidders.
Page
That
42.
is- Page 42 is the tender document,
Yes.
tank truck.
Yes.
Now, my lord, I am challenging few of the conditions.
Yes.
Your lordships kindly come to, I will be very short, my lord. Rather, I will be very short today.
No, you can be.
No, I have also another one matter fixed at 2 p.m. I am partnered matter.
Now, Mr.
Continue.
Bandyopadhyay, I don't know which one is more lucrative, this one or that one.
No, I am pressing it.
No, I don't know which one is more lucrative for you, this one or that.
Not the lucrative. My lord, this is that's only the client's interest and nothing.
I'm just kidding.
My lord,
Yes.
today, after this 43 or 44 years practice, my lord, not the lucrative or non-lucrative, every day.
The younger one is sitting there.
Yes, not for me. Now the question is, my lord, the interest of the client, some important matters that there are some.
Yes.
Now, my lord, kindly see, first of all, kindly come to page 51.
51.
Is a total requirement.
Yes.
Page 51 is the total requirement.
Yes.
This is, my lord, projected truck requirement 202. Estimated bulk is 25,735. I am on 2,202. Now, my lord, kindly come. Now it starts. Kindly come to page 56, Constitution.
This is for the 18 MT, right?
My lord,
This is 18 MT. 18 MT.
yes,
This is for
18 and
18 and 21.
both 18 and 21. Now, my lord, page 56. First, your lordships kindly see reservation for scheduled caste, scheduled tribe, women, general. Lord, I am challenging this clause. I am challenging this clause because, my lord, reservations only can be made under a statute, and which is the, my lord, Constitution has given the power to make reservation.
Kindly see, my lord, Constitution.
This is your first,
First point, Article 15, your lordships kindly see Article 15 of the Constitution. Constitution नहीं तो दाओ ना तो देख सके honestly act है दाओ सबको दाओ any huh why not can you take this Article 15 to 15 first point kindly see
Constitution हमेशा होना चाहिए.
15 sub-article 1. Your lordships will kindly find that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex, place of birth, or any of them.
Yes.
Now, my lord, the constitutional power has been given for reservation of the scheduled caste and scheduled tribe.
Yes.
This is a constitutional power. Still, kindly come to me, Lord.
Five.
Nothing in the subclause D of Article 19 shall prevent us from making any special provision. No. 4. Nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of a socially and educationally backward class citizen or for the scheduled caste and the scheduled tribe. And 3, see, nothing in this article shall prevent us from making any special provision for women and children. Then provision has to be made. Now, my lord, your lordships will find that Article 16 makes the provision, my lord, for reservation of the scheduled caste, scheduled tribe for the post service matter.
Yes.
Now, therefore, first is that Article 15(1) does not give, my lord, any. There is no, my lord, inequality. They are all are equal. Therefore, 15(4), nothing in this article, nothing in this article or in clause 2 of Article 29 shall prevent the state from making any special provision for the advancement of any socially and educationally backward classes, citizens on for the scheduled caste and the scheduled tribes. Then there must be a statute for that extent. And scheduled caste, scheduled tribe reservation order, my lord, that is speaks about the post. And my lord, women reservation, so far the, my lord, the just constitutional amendment was made for the women reservation in the parliament and the assembly. That's a different thing. Now the point is, first point is the, my point is there is no scope of reservation. Now, my lord, second point is, my lord, kindly come to, my lord, take volume 3. Volume 3 content. Volume 3 kindly take, my lord. (370).
Yes.
370 kindly see. Work description, bulk LPG transportation. My lord, got it, my lord? The transportation contract by road for the state of West Bengal. First is 2. Tender docket times so and so 2. Truck allocation order. Subject to finalization 21 metric ton rates. My lord, right hand side.
Yes.
Truck allocation order now subject to finalized 21 metric ton rates lower than finalized 18 metric ton rates and state register truck quoting at floor rates.
Yes.
This is given. Now the condition is given 21 metric tons ready truck first priority, 21 metric ton truck some state so and so, then 21 metric ton SUS, SC, 21 metric ton ready other state, 21 metric ton ready other state. Then Miller kindly come 18 metric ton, then 18 metric ton, 18 metric ton, Lord, this 80 metric ton formula has been given. Now, if your lordships kindly see, my lord, how it will be taken up. My lord, kindly see rates to be quoted. That your lordships will get it from. Kindly come to page 61 volume 1. Kindly come back.
Yes.
Similar rates to be quoted. 7. Bidders will have to quote their rates in the price bid only with the 0% of BMR band mentioned for the particular capacity of the truck offered by the bidder. Bidder must ensure not to copy and paste figure text from other Excel sheets so and so. If bidder does not quote truck but offer rates for a particular category vice versa, then such rates shall not be considered for evaluation. The rates as percentage of the BMR should be quoted strictly between the minimum and the maximum band for all slabs of 5% only up to 10 decimals for a particular capacity truck 18 metric tons stroke 21 metric tons or different capacity trucks as per bidder offer. The bidder to quote rate 0% so and so plus minus 5% of the price band. Now, your lordship will get it from the page 62, floor price, lowest rate, ceiling price, highest rate. Now, my lord, kindly see, rate now has been fixed by them. Kindly come to rate. That's going to page 40. Kindly come to page 40.
Yes.
See, my lord, just I'm giving one example. See, 18 metric ton, kindly come to extreme right schedule rate 656.7689.
Which serial number?
Page 40, serial number 1.
Yes. 18 MT.
My lord, got it?
Yes.
6.
Yes.
656.
Yes.
Now, my lord, kindly come to this after this second part, 21 metric ton. There the schedule rate is 611.6494.
Yes.
This is 5% plus minus.
Yes.
Then if the 18% rate is higher and 21 metric ton case rate is lower, then automatically, my lord, 18 will be L2. Later,
21 metric ton will be L1.
my lord, every time 21 will be the L1. 18 cannot be L1. You are fixing rate. You are asking for tender, 18 metric ton. You are saying 21, this is the first category. Then the 18 will get the priority. Then so far fixation of the rate is concerned, rate is fixed, lower rate the 21. So far 18 is concerned, higher rate, plus minus. I can't go beyond minus 5. Then is it a discrimination? 18 will never get the chance. জজমেন্টের পাশ যেটা তোকে বলেছিলাম রামের কাছ থেকে নিতে বলেছিলাম
Yes.
Now, my lord, kindly come next point.
Yes.
Kindly come to, my lord, page 321 of the volume 2.
Yes.
Kindly come to, my lord, page 321.
Yes.
But in all the tenders, either irrespective of the company, same clauses. My lord, kindly come to page 321.
Yes.
See 7.7. Each bidder can submit only one bid. It is clarified that a person shall be deemed to have submitted multiple bids if a person submit more than one bid either individually or in a individual no difficulty or in a combination of person, individual provides so and so persons and company. Then therefore, my lord, suppose my lord, I am a individual.
Yes.
I am also shareholder of a or director, maybe one company.
Yes.
And company is having a completely different legal entity. Then I cannot do it. If a company is a completely different legal entity, how can I be debarred?
These clauses are there in almost all tender documents. These clauses are very
these
boilerplate clauses. Which
may I say, may I permit, Milord? This is the one of the clause, this judgment. I told my junior that I have argued the matter in Sonali Foods. Division bench of the Calcutta High Court has said, presided over by Justice Sonjeev Banerjee. It's a completely different entity. You cannot say, no, I am being an individual and I am a company, therefore I can't participate. I argued the matter, Milord.
all right.
Anyway, Milord, kindly consider this point. If Milord, maybe Milord, your lordship is absolutely your lordship is saying correct, but my submission is this. Kindly consider this point, Milord. Maybe Milord, different tender it is there. It may not be have been challenged. I don't know.
Yes. Yes.
Same clause, same clause 7.7 200 volume 2 taki paper. Now, my lord, kindly see, allowing participants to agreement and sell. Next point, mine. Page 415 of volume 3.
Volume 3
Page 415. 415.
Yes.
This serial number 5, right hand side.
Amendment করে 4th April ঢুকিয়েছে প্রথম।
This has been, the bold portion has been amended and inserted. The bidder should upload the self-attested copies, RC book, all offers and copies are defined in the scope of all. The bidder must own at least one truck of them. If the bidder does not have minimum one truck, then the bid of such bidder will not be considered. Next, in case of TTs operating in the existing contract, whose ownership cannot be transferred during the...
I'm little lost. Which page?
My lord, sorry, my lord, page 415.
415.
415.
I'm sorry.
Maybe I have...
No, I'm sorry. No. I think I misheard. Yes.
Kindly see page 415.
Yes.
The bidder should upload the self-attested copies of RC books of all offered trucks owned and attached or capacity as defined in the scope of work above, out of which the bidder must own at least one truck in their name. If the bidder does not have minimum one owned truck, then the bid of such bidder will not be considered. Then kindly see, in case of TTs operating, keeping in this clause, whether now the bold words it has been written, in case of TTs operating in the existing contract whose ownership cannot be transferred during the pendency of the running contract, and hence the formalities for transfer of ownership could not be completed as on due date of the new tender, such vehicles can be sold to an agreement to sell. And both the seller and the purchaser shall have to submit affidavit as per the attached form with the valid registration. Such trucks shall be considered the own trucks of the bidder for bid qualification. How this can be done? If I am not an owner of a truck, I cannot participate in the tender.
Yes.
But because of this, today I am under the existing contract. I entered into the agreement for sale to sell this stock to the contractor or someone. If he participates and successful, then he can be the success. His stock can be treated as then can buy an agreement for sale. Ownership comes. If the ownership doesn't come, then he cannot participate. Agreement for sale between the two parties.
Yes.
Agreement for sale does not give the ownership.
Yes.
Therefore, this clause is also, my lord, I am challenging. Then, my lord, last clause I am challenging, that is, my lord, fixation of price which have been given. What is the basis of formula? Kindly come to me on my paragraph number 22 to 24. I have said so.
Yes.
Company judgment.
Para number 20.
22 to 24.
Yes.
But this is, I have given the price fixation. But let me be very candid to your lordships, my lord.
Yes.
That arena, it is a little difficult for me. Fixation. I am very candid because I am not much I am personally also not much very convinced this point has been taken. But I am my 4 points. Scheduled caste, scheduled tribe. Then the second point is discrimination 18 rate. That is more important point. That point number 2 should be the point number 1. And then, my lord, multiple breeding allowed. Your lordships have made certain observations. So, then allowing participation by sale agreement. One judgment I will show, and my lord, I will finish this. Company, lordship, my lord, this law is also well settled. Paragraph 22. 1988 supplementary Supreme Court cases 488. Paragraph 22. No, judgment 1998 supplementary Supreme Court cases 488. It is true that the company is a legal entity distinct from its shareholder. It is a juristic person, and the fact that another company is a shareholder, even a major share, does not affect the legal distinction between the two entities. Completely different. Lord, I can understand a partnership, husband and wife, or a partnership fund. I can understand. But a company is completely having a total. Therefore, I am, Lord, 30th April is the last date for the submission of the tender. And that is the, Lord, the urgency has been arisen. And Lord, I will be praying for stay of operation of this tender, Lord, for the time.
And we'll decide it before that.
Pardon me?
We'll decide it before that.
Okay. There's no.
Yes.
I don't know.
They'll file up.
Only, Lord, only if your lordship wants to keep it, Lord, kindly do not keep it on tomorrow, Lord. For my health ground, I will not be there. I have to go to Delhi, no doubt, but for my health ground.
You have already made your submission.
That's right. I have made my submission. If my junior,
yes, he is there.
Mr. Bandopadhyay is there. If anything, he is. This subject is known to him better than me. Leave still lordships. With your lordships, leave me. Can I go?
Yes, yes. Yes.
I am appearing on behalf of respondent number 1.
Please take the mic.
I am for Bharat Petroleum. Respondent number 4 and 5.
Who's your senior?
My lord,
Who's your senior?
there are 2 other oil companies also who are appearing separately.
Yes. Yesterday you pointed
my
out
lord,
that-
my senior is Mr. Joydeep Kaur, my lord. My lord, he is on legs before some other bench, my lord. That is one difficulty.
All right, let the others start.
Yes, but I will argue in case, my lord, he does not arrive, my lord. I'll argue. I'm ready to argue the case, my lord.
Yes.
Sir, my humble submission before your lordship is
You appear for the HPCL. You are appearing.
HPCL. BPCL, Bharat
BPCL,
Petroleum.
Bharat Petroleum.
There is HPCL and IOCL also.
Yes.
But I'm for Union of India. I'm representing Ministry of Petroleum.
Yes.
All these oil companies are,
Under you, under your aegis.
yes, under the Ministry of Petroleum.
Yes.
But my humble submission before your lordship is this.
So just take the mic, please.
Lordship.
Mic.
Oh. My humble submission before your lordship is this. That my lord, if your lordship can come to the prayer portion, my lord, an interim order cannot be passed in the form of final order without giving my lord opportunity to file opposition. My lord, it cannot be passed, first of all. And this cannot be stayed as because this is public utility service. Third one, my lord, there is a clause of arbitration. Lordship kindly come to page 101.
That is only applicable if somebody enters into a contract.
Pardon?
That will be applicable, son, to somebody who enters into the contract.
Yes.
Today, the arbitration clause will not be relevant.
That's right. But opportunity to be given, my lord, to file affidavit in opposition, and no interim order can be passed in the form of final order. If your lordship can come to the prayer portion, lordship will find therefrom that an interim order and final order both have been
Make your
the same.
submissions. He has given 5 points, 4 points basically. Counter those 4 points.
My lord, those Article 25.
Article 15.
Yes. But these are the conditions which have been, my lord, mentioned in the contract. My lord, if someone, my lord, this is notice inviting tender, e-tender. My lord, those who are interested, they may submit, participate in the bid. If they are not interested, they may not. My lord, this is the condition which have been laid down, and that is there. And nobody has come up other than this particular person, my lord, to challenge this. And that would be replied, my lord, on oath by the affidavit in opposition.
Sir, are you prepared to argue right now?
Right now, my lord, I'm not
Then you are.
entirely prepared. Neither I
You
could
should
have.
be prepared. These are tender matters, sir. You should be prepared.
My lord, at the outset, I'll say, my lord, this is a tender for, my lord, a supply of bulk LPG from the manufacturing plant to the bottling plant. And this is for West Bengal. And in all 3 oil companies, around 850 trucks will be required for 5-year contract. Now, my lord, the previous contract was issued in the year 2018 for a period of 5 years. And it was subsequently extended for another 2 years. So the present contractors are running the show for about 7 years. And my lord, the present writ petition is also at the behest of those contractors, my lord, in order to stall the tender process and engaging new contractors, my lord, in order to inure to their personal benefit. That is the first part of the other part is, my lord, it would appear from record also, my lord, similar advertisements have been floated all over the country. My lord, so far I could gather information from my instructing officers, my lord. There is no other challenge, my lord, except for one challenge before the Patna High Court, my lord. This is the information I could get, my lord, on the same terms and conditions. My lord, now, my lord, so far as
what is the status of that?
My lord, the same, all the contractors are applying under the same terms and conditions.
Saying what is the status of the petition?
My lord, no order has as yet been passed by the Honorable Patna High Court. Now, my lord, the first point, my lord, addressed by my learned friend on the issue of reservation is concerned, my lord, it touches, my lord, so far as my reading of the brief is concerned, my lord, it touches only Hindustan Petroleum Corporation. My lord, it does not touch Bharat Petroleum or Indian Oil. Reservation. Less.
No.
Now, in my case, it is less.
Appearing in item number 3 for Union of India. I suppose my learned senior friend has made submission on behalf of Union.
No submissions have been made by him.
Are
Are you prepared, Mr. Trivedi?
No, I'm not. My lord, Union of India is not an answering respondent. That's why this is kind of.
He said because the Petroleum Ministry,
Yes,
everything comes under the aegis of the Petroleum Ministry.
Yes,
They are
But my lord, as far as, because my learned friend has been briefed in item number 1, and I am in item number 3, my lord. So I got confused because all the 3 matters are being taken up analogously.
Are you prepared?
No, my lord, as far as of today is concerned, my lord, because I was briefed only yesterday, I have not even.
Then let him make the.
Yes, my lord. I apologize, my lord, for intervening.
That I'll do. First, let me show. If lordship comes to page 156, which is at volume 2, my lord, it pertains to Bharat Petroleum, my lord.
Yes.
156.
Yes.
156. My lord, total requirement of trucks by Bharat Petroleum is 358. And if your lordship sees the statement in tabulation form, serial A, B, B1, B2, at D, SC, ST total is 151. 151 out of 358 is less than, my lord, 50%, my lord, as per my calculation.
Yes.
So, what they have done, this is a, my lord, misjoinder of cause of action in the same writ petition.
Yes.
My lord, he has challenged 3 separate tender notices floated by 3 companies, oil companies, all challenged in one writ petition, my lord. And the merits of the case could be different. As I have demonstrated from here, there is no break of reservation policy. Apart from the fact, my lord, I will also demonstrate, even if we had really crossed the limit of reservation that is permitted under the Government of India circular, my lord.
So this is the tender for floated by Bharat Petroleum, right?
Bharat Petroleum. This is Bharat Petroleum. My lord, lordship will kindly take. My lord,
yes.
my lord, even assuming the reservation quota has been crossed over, my lord, this is a notice issued by the Government of India, my lord, in August, as early as August 1994. My lord, if your lordship sees, here the government has fixed, my lord, for Ministry of Petroleum, it has been decided by the government that after careful consideration that reservation will be provided to the members of scheduled caste, scheduled tribe in engaging road transport trucks for movement of all petroleum products such as LPG, MS, HSD, SKO, lubes, etc. in bulk or packed by public sector oil companies subject to following guidelines. Thereafter, the guidelines are there, my lord. I will not trouble with that. Lordship will come to the next page with the paragraph starting if adequate number of SC, ST candidates are not available in a particular year, the unfilled quota may be allotted to unreserved categories in that year. However, the unfilled quota may be carried forward to the next tender also and offered to SC, ST candidates. If the quota of the previous tender is not filled, even in the next tender, the unfilled quota of the previous tender may be de-reserved and allotted to general categories. So, my lord, though not Bharat Petroleum, but other oil company, if they have, my lord, taken care of this carried forward formula, my lord, there could be a possibility that the reservation has exceeded 50% following the government guidelines. Apart from the fact, my lord, misjoinder of cause of action. Now, my lord, so far as, my lord, page 321, where single application has been urged by my learned friend, Lordship, clause 7.7.
Where? Page?
Page 321. My lord, my learned friend has said each bidder can submit only one bid.
Yes.
That is against policy.
Yes.
My lord, my submission is, my lord, this has been included to prevent cartelization. My lord, I apply as a proprietor. Next, I apply as a partnership with my brother. And this can continue to any number of times. And no one can stop me. And I will be controlling the entire affair. There could be 20 applications, out of which in 18 I am a member. To prevent that, my lord, that cartelization or syndicate issue, my lord, this has been included, my lord.
Yes.
of 415 এটা আমার নাকি ওই টাকা এটা আমার My lord, my learned friend has also demonstrated before your lordship page 415, my lord, regarding my lord transfer of ownership.
Page
415, my lord, volume 3. My lord, he has referred to the bottom portion, yes, the letter marked in block. My lord, he has read up to page 416, the second paragraph, such trucks. My lord, if your lordship continues to go through it, my lord, this is in order to facilitate, my lord, supply of, my lord, essential commodity. My lord, provision is there within what time they will have to furnish the ownership document. They have to put in a caution money of 1 lakh per truck up to maximum 10 lakhs. And then within 4 months, which is the third paragraph in continuation, if they fail to do, they will be terminated.
Yes.
So here only to facilitate application by many applicants and for using trucks which the present owners may not be able to ply for another 5 years or not in a position to continue with the contract. My lord, they may create interest of a third party by an agreement of sale. And here the term says that the entire process has to be concluded within 4 months. Otherwise, my lord, my lord, will be forfeited, their SD will be forfeited and their LOI will be terminated, my lord. And so far as the cost part, my lord, is concerned,
yes,
which is at page 40, my lord, which my learned friend said it should have been his first point and not the second point. Now, my lord, in the last tender in 2018, my lord, 21 metric ton trucks were already there.
Yes.
With a reservation of 15%.
Yes.
If your lordship sees page 40, my lord.
Yes.
My lord, he has made a comparative study of serial number 1 in 18 metric ton vis-a-vis serial number 1 in 21 metric ton.
Right.
And tried to demonstrate that because of this price difference, people with 21 metric ton will get a preference. My lord, there are 2 submissions on this. In the 2018 contract, there were also 21 metric ton trucks. It was capped at 15% of the total number of trucks required. This time it is capped at 25%. So 75% remains open for the 18% ton truck owners. And if, my lord, the 21 metric ton truck owners are not in a position to supply trucks up to 25%, the balance portion which is not fulfilled will be taken from the 18 metric ton quota.
No, he has another point also. He is saying that the rates which are given for the 18-ton metric MT trucks is higher.
Yes.
So they will never be the L1 bidders.
My lord, this was also there, my lord. This is to prioritize, my lord, larger vehicles, my lord, because those are modern vehicles with BS4, BS5 standardization. My lord, in order to facilitate those advanced vehicles, my lord, we are indulging in this, my lord, and not cost benefit to the company, and not that this is for the first time we are doing this. This was prevailing before also.
Same rates are there.
Yes, this difference. The rates were different, of course, but
the 18 was always
No, the
18 was always higher. On instruction, I'm submitting that. 18 was always higher than 21 in 2018. The rates in number could have been different, but the proposition of being higher and lower was always, my lord, tilted towards 21 being on the lower side, apart from the, my lord, technical side. Now, my lord, these are more or
Was
less
your
on
earlier tender challenged? 2018.
2018 contract.
Yes, was it challenged?
My lord, Were they challenged? No, my lord, as per my instruction, my lord, subject to correction, what I get from my officer, my lord, they were not challenged. 2018 was not under challenge, my lord, subject to correction, my lord. I am not in a position to confirm that.
There were certain individuals who challenged my lord on different points. The points were not same.
But no, they could not, my lord, as per my instruction, no orders were passed in their favor. They could not get any order on this.
That regional and state-wise was the one which was challenged,
My lord, the earlier one was zonal.
zonal one.
No, earlier, no.
Bombay.
2018 one was state-wise. Prior to that, it was zonal.
The Bombay High Court is prior to that.
Yes, the earlier one was 2018, 2023. Then two more extended years in the ad hoc rates were there.
Yes,
My lord, the present association members who are the writ petitioners before your lordship are also participant in the previous tender, and they are some of them are, or most of them are operating also. They had not challenged, my lord. My lord, I will rely on some judgments on the, my lord, terms and conditions of the tender, whether can be amended by.
So why don't you do one thing? Why don't you file your affidavit in 2-3 days? We'll decide this matter before 30th.
My lord, only thing is that when it is opening, 30th. My lord, we are opening the tender on 30th, the technical bid, and thereafter the price. My lord, subject to my lord, our kind prayer before lordship will not touch the schedule, my lord. We'll come back any day your lordship directs us.
So you file it within 2 days.
Yes, my lord, see, if the process continues, my lord, I will suffer, my lord. I will suffer.
My lord, so far as the, my lord, judgments, will annex them with the written argument.
Yes.
Or will it be a written argument if your lordship desires?
Whatever you want to file, you file your affidavit along, and you can give me the written arguments also along with that. We'll keep it on 20. Today is what?
My lord, Monday is 28th, my lord. And the last day of submission is 30th.
We'll have it on 28th, Tuesday.
Advance copy to me, my lord, by Sunday.
Lordship 29th. By Sunday we cannot give, we'll give on 28th. Because we are getting one working day tomorrow. We'll get it ready at the earliest by 28th, my lord. We'll give them a copy on 28th.
You file in advance to the court also. You hand over a copy in advance to the court.
The court also.
Yes.
On 28th.
On 28th.
We'll give an advance copy, my lord.
We'll have it on 29th then. All right.
My lord, in the meantime, petition number 1 being an association,
Yes.
may the members participate without prejudice to their rights and contentions.
They have to participate.
Well, without prejudice to their rights and contentions.
My lord, in that case, my lord, we can have one or more.
No, but the date will close. No, but the
Since
date
they are
will.
participating, my lord.
Participating in that.
Since they will participate, it will
Well, without prejudice. My lord, without prejudice.
Without prejudice means
let
the
them
same thing.
participate.
My lord, if the restrictive clauses are such that everyone will not be able to
Try
participate.
to answer your lordship's queries.
Everyone won't be able to participate because of the restrictive clauses.
There are no restrictive clauses as such. Everybody would participate.
Well, the multiple bidding is a restrictive clause.
Multiple
The 18
bidding,
and 21 metric ton is designed in a different manner.
it was there before also.
No, this one come by on 4th by way of a corrigendum. This has come by way of a corrigendum. Both.
Multiple bidding has been dealt with by the Honorable Delhi High Court.
Yes, yes, multiple bidding we don't.
Yes, my lord, it has been decided that the embargo is legal, my lord. My lord, whatever date lordship schedule
29, we'll come back on 29. We'll come back on.
If you are participating, then we'll have it.
My lord,
No, my lord,
some more times that we
keep
can
it on
answer.
29. Can I decide the point?
My lord,
I decide my.
my lord, all the 3 companies will have to file and we'll have to reply to the queries which fell down from your lordship, my lord.
Only 4 queries, sir.
Yes, we'll do it, my lord. Certainly, we'll do it, my lord.
Absolutely. Not dealing with the entire writ petition.
Those writ petition contains those 4 points only, 5 points.
Confine it only to those 4 points.
Lordship.
The petition, the present writ petition is challenging the bulk LPG. In the present writ petition is challenging the bulk LPG transportation tender being NIT number. What are the different NIT numbers?
4 and 5, my lord. I appear for 4 and 5.
NIT number, sir.
NIT number
Lord,
is separate, my
Lord, LPG stroke BULK bulk stroke TT
Stroke IOC stroke WB 2025 hyphen 30.
Yes.
Same LPG bulk TT BPC slash BPC BPC slash WB 2530 25 hyphen 30. And which is the third one? LPG bulk TT HPC. HPC, right? HPC slash WB 25 hyphen 30. Issued by respondent number 2, 3, and 6, right?
2, 4, and 6.
2, 4, and 6, respectively, being the oil marketing companies for the bulk transportation contracts by road for the state of West Bengal.
Item number 3 is
The petitioner is challenging the said tender on the ground that the tender is arbitrarily designed to benefit certain classes and contractors to the exclusion of others, and the clauses of the said contract defeat the purpose of fair play and level playing field. Full stop. Level playing field. Full stop. It is the submission of the learned counsel for the petitioner that petition number 1 represents. Petition number 1 is the empty trucks, right? 18 empty trucks.
Yeah, petitioners number 1 is association. It has all. 2 and 3
Petitioner
are total
represents
18.
18 empty tank trucks and is part of All India Bulk LPG Transportation Federation. Transporters Federation. Transporters Federation. Full stop. It is the case of the petitioner that the impugned tender is designed unfairly to favor only 21 empty TTs by setting the benchmark record bracket BMR significantly low for them. Full stop. Despite state-wise tender framework, preference is given to 21 MT TT from outside states over local 18 MT TTs. Full stop. It is further stated that this automatic disqualification, which combined with lower BMR for 21 MTTTs, structurally is disadvantageous to 18 MTTTs. Full stop. He further states that major procedural changes like permitting agreement to sale as proof of ownership without RC or peso license permitting agreement to sale as proof of ownership without RC or peso license promotes the participation of unqualified bidders. Full stop. There are representations also which are pending. You could have decided that also.
My lord, those were taken up, corrigendums were issued. But my lord, if further anything is pending, my lord, I'll ask my lord, lordship will make an observation, lordship.
Is there any further representation?
My lord, there are at least, my lord, representations from 20th of March as late as of 19th of April, which is part of, we have made it part of our supplementary affidavit, my lord, which we did not place. My lord, up to 19th of April, they have not replied to any. My lord, I do not think, my lord, at all interested, my lord, in replying to our representations?
The petitioner further states that the allocation/reservation of quota for SC/ST women is in violation of Article 15 of the Constitution. Full stop. Learned counsel for the respondent.
We have issued 4 corrigendums, my lord.
Respondent, IOC,
My lord, I am 4 and 5.
PC and HPC, as well as the Union of India, states that they shall file their affidavit, reply in the form of affidavit. What do you call it? Affidavit.
Opposition.
Affidavit by way of opposition by way of affidavit. Affidavit in opposition. No, these terms, I have to get used to these terms. Affidavit along with written submission, not running more than 5 pages, with any judgment they wish to rely upon by 28th, with advance copy to the petitioner. Full stop. Let this matter appear on 29th.
Could it be at 2 p.m., my lord?
2 p.m. Affidavit, जहाँ लिखा ना affidavit in opposition, addressing primarily the contentions raised by the petitioner in the presented petition. Anything else?
My lord, I would only pray for an extension of that bid submission time, my lord, if it commences to your lordship. But since your lordship hearing out the entire matter, my lord,
we'll finish it.
My lord, 3 is also same. 3 is an individual contract.
Individual, same order.
Same order.
Same order.
But it's an individual.
Who appears?
I appear for the petitioner.
HPCL Chilo.
Item 3 also same.
My lord, all the councils same except for I think the Mr. Trivedi is appearing for
Item
Union of India.
Union of India, Mr. Trivedi in item 3. Dheeraj Trivedi.
তিন নম্বর single আছে individual.
Only he is changed in item 3, otherwise everything everyone is same.
1 and 2 you are appearing.
Only one.
2 is not this matter. 2 is a separate.
1 is appearing, 3 Mr. Trivedi is appearing.
He wrongly stated item number 3. It is respondent number 3. That's why some.
No. Item number 3.
Item number 3.
Respondent number 3 is some tendering authority of oil
No,
company.
sir, he is appearing for Union of India.
We are appearing same.
Anyway, everything is same except for. Wait for a minute.
Directive officer so that order may be uploaded.
Order will be uploaded. Order will be uploaded, sir.
But the affidavit of service may be kept.
Affidavit of service taken.
My lord, extremely sorry for what happened. Extremely sorry for what happened yesterday.
No. You know what I didn't? Honestly, I'll tell you. I don't like the fact that you showed me the warrant.
I admit my delivery. Lordship will kindly not.
Otherwise,
No.
you know, I am sitting
My
here.
lord, I bow down, my lord.
I am sitting here to do work for you only, sir.
We are fortunate, my lord, that your lordship gives us
Lordship will kindly.
hearing every time.
Yes, sir. Why not? Why not? You all deserve patient hearing. Affidavit of service taken.
Grateful, man.
Grateful.
Thank you. What is your name, sir?
Sanjeev Kumar Mal, MAL.
Mr. Mal. Thank you, Mr. ठीक है, इसको अपलोड कर देना आज. इसको अपलोड कर देंगे आज. Before I leave ना साइन करा या डिजिटल करा के करा. How did you get this matter fixed? How did you get this matter fixed?
My lord, I mentioned it thrice, my lord, before lordship, my lord,
I
because
didn't allow your mentioning.
my lord,
I had not allowed your mentioning. Anyway, give the file.
Item number 2.
My lord, learned counsel, Mr. Bhattacharya is leading this matter as he is engaged with another court. So I'm paying for fix the matter next day, tomorrow. My lord.
What is the matter?
My lord, the petitioner has come before Lordship, my lord, challenging a notice for execution of a warrant for disposition of the petitioner by taking over the physical possession of his residential house in pursuant to an order passed in a passed in a proceeding under Surface Act under Section 14 of the Act, my lord. May I place the notice first, my lord, before Lordship as page 50?
Yes.
Page 52 is the notice, my lord. Your Lordship kindly sees the order of the order, my lord, which he intends to, my lord, execute. Date of the order is 22nd of August.
Just a minute. Saurabh, use file में डाल. Last matter.
Page 52.
Yes.
This is the notice I have challenged before Lordship. Your Lordship kindly sees the subject, third line. My lord, date of the order 22nd of August 2023. File miss case number 73 of 2023.
Where are you showing, sir?
My lord.
Where?
My lord, subject.
Page 52.
Page 52.
P6.
P6.
This is Abhishek Chatterjee, advocate.
Mr. Abhishek Chatterjee is the commissioner. Lord, I have come before Lordship on 2 grounds.
Yes.
This Mr. Abhishek Chatterjee, who moved the matter on behalf of the bank before the magistrate, and that is why he cannot be appointed as a commissioner.
What document you have to
My
support?
lord, I have. I'll produce. And the second order, second is, my lord, at this juncture, this notice cannot be issued. My lord, the reason I will also explain. Your Lordship kindly sees Mr. Abhishek Chatterjee, my lord, subject. The third line of the subject, my lord, the order date is referred 22nd of August 2023, white miss case number 73 of 2023. This is the order, my lord, in which warrant was issued. My lord, he wants to execute this order. My lord, may I read it, my lord? This is to inform you that to comply with the reference of Chief Judicial Magistrate Barasat, North 24 Parganas, the undersigned requests you to vacate the below mentioned property on or before 15th of April 2025 and shift all your movable asset from the property. The undersigned will initiate possession of the property on any date after 19th of April 2025. This is the order. The genesis of the order, may I refer, my lord? Now, if your Lordship kindly turns to the certified copy. Second page of the certified copy. Page 1 of 4. Certified copy. The certified copy attached there in the
page 4.
There is no pagination. Certified copy.
Certified copy.
Page 2. Page 2, my lord. Second page. Page 1 of 4.
Yes.
Your Lordship will kindly see the order date 22nd of August 2023. Now, your Lordship kindly turns to the operating page. Wait
a minute. Wait. You are showing me this order, page number, Miscellaneous 73. What are you trying to show in this?
The date of the order, 22nd of August 2023. This is the order passed under Section 14 of the Act. Ordering my disposition, ordering
22nd August is, this order has been
22nd August 2023.
Sir, this order has been passed when? On 14th?
No, my lord. This order has been passed on 22nd of August. If your Lordship kindly sees
next page. All right.
First page of the order.
Yes. All right. Yes.
Your Lordship kindly sees the date of the order 22nd of August 2023. Now, your Lordship kindly turns to the operating page, page number 3. First, the schedule of the property is given. I am reading from that part. The learned advocate Abhishek Bhattacharya is hereby appointed as officer taking physical possession on the scheduled property for respondent after notice for delivering the same to the authorized office same to the authorized officer of the applicant bank company and secured credit. The inspector in charge such and such police station, this is the direction upon the inspector in charge for providing assistance. Now your lordship kindly turns to the next page.
Yes.
The applicant is to bear the cost of providing force by police by as per law. Let the original document is written. Now under the relevant portion. 223/3/2024 for compliance and report. 23/3/2024 for compliance of report. So, warrant was issued for execution of this order by 22/3/2024. Now only if lordship kindly sees the next date. Next date I will come later on. Challenging this order, I approach before the tribunal. Now, tribunal was pleased to date is very relevant. We waited for 7 months. The bank didn't take any step. We didn't take any step. Now, after 7th month, we obtained an order of stay. If your lordship kindly turns to the page. Your lordship kindly 36, 38. 30 is the relevant part. This date of this order was 26th of June 2024. If your lordship kindly sees, the warrant was supposed to be executed by 22nd of March 2022. 2024. The warrant was supposed to be executed by 22nd of March 2024. They didn't do anything. Now we obtained a stay order on 26th of June 2024. If your lordship kindly sees page 36, the date of the order. Page 36 is the date of. Your lordship kindly sees page 36, the date of the order. And the relevant part.
Page 36 is the date of the order, 26/6/24.
Yes.
Yes.
After waiting for more than 7 months from the date of the order, even after 3 months from the last date of execution of the order, we obtain a stay order from the tribunal. If your lordship kindly sees page 38, the relevant part, staying the operation of the order impugned, as I referred. Respondent bank is directed not to take any coercive step in respect of secured property on the basis of the impugned order dated 22nd of August 2023 passed by the CGM North 24 Parganas without leave of this tribunal. Next date is fixed. Challenging this order, the bank approached before the appellate tribunal. Now, the appellate tribunal was pleased to vacate the order, vacate the stay order, and directed for execution of the order dated 22nd of August 2023. Now, our submission will be at this juncture, without a fresh warrant being passed by the Chief Judicial Magistrate, they cannot execute this order. Because now, your lordship kindly sees the next dates, as I referred earlier. What was happened before the magistrate court on the next date. Now, your lordship kindly sees the certified copy once. What happened on the next dates? Date is fixed for report. No report.
Just a minute.
This is on 22nd of March 2024. That is the returnable date for execution of the warrant. Warrant couldn't be executed. Subsequent thereto, we approached before the tribunal. We obtained an order of stay. The subsequent thereto, they approached before the appellate tribunal. Appellate tribunal vacated the stay order. Now, on the strength of this order dated 22nd of August 2022, they issued this notice. This they cannot, because the date of execution of warrant has been expired. They will have to obtain a fresh order and fresh warrant from the learned court below for execution of the order. Now, this is my contention. I am covered by division bench judgment of different high courts as well as judgment of Supreme Court that this cannot be done. No, no, when you go back.
Yes, show me. You're challenging the order of the DRT, huh? DRAT.
मतलब your lordship kindly sees मतलब paragraph 6 मतलब 5, 6 are relevant exactly मतलब the position explained as I have explained before lordship मतलब.
You explained.
Therefore, section 14 of SURFACE Act is an enabling provision through which the secured creditor may seek assistance of CMM in taking physical possession of the secured asset. It is to be noted that section 14 is silent with regard to time of limitation of taking possession. The only limit for contemplated in section 14 is that CMS is required to pass an order within 30 days from the date of application by secured creditor. The secured creditor, then your lordship kindly turn to page paragraph 6, the second paragraph. An essential component of judicial order is certainly if the CMN possesses a time limit for taking over possession, such stipulated time has to be mandatorily adhered to. There, the stipulated time was given for execution of the order and warrant was issued. Within that period, they didn't do anything. Now, if the same is not done, be it for whatever reason, the appropriate course of action is to be reapproached to the CMN. That was my contention. They will have to reapproach the CMN for a fresh warrant. This warrant they cannot execute. For execution, for extension of time, we are of the clear view that reasonable time limit should be imposed by the CMM in their wisdom and discretion. Although the context of recovery of excise duties, this is referred to a Supreme Court judgment also. I have also had that judgment before, and which I can place before lordship. This is the proposition I want to place before lordship. This order they cannot execute now without the time being extended or without.
This is not your case.
This is my case.
This is not at all your case. There's an order which has been passed by the CMM.
Yes.
Which was challenged before the DRT. The DRT on the ground that the order has appointed Mr. Abhishek Banerjee, who happens to be the lawyer of the bank. On that ground, the order was set.
That part I will place. That part I will place.
Listen to me. And then after that, you had approached the DRT. DRT said no, there is no evidence to state that Mr. Banerjee was the lawyer and has set aside that order. That order is under challenge before this court. Your CMM order is not under challenge before this court. And the time limit which you are talking about is not under challenge in this court. Right? None of those issues are under challenge before this court.
Your lordship kindly appreciate.
I'm appreciating it.
Your lordship kindly appreciate. For whatever reason, if they fail to execute that warrant within that specific time limit, they will have to get the time extended from the CMN's court. they cannot now
Let
they
them do whatever they have to do. Today, that issue is not before me.
by
That issue is not before me, sir.
your lordship kindly
Yes.
sees my prayer, my lord. By dint
Your
of
prayer can be anything.
my lord,
You can ask moon also. Doesn't mean I'll give you.
no, my lord. Your lordship kindly see, my lord, by dint of that order and that warrant, they
Sir,
cannot.
what are you challenging? You're challenging the order of the DRAT. Are
No,
you
I'm challenging the
the
notice. I'm challenging the notice itself. That notice cannot be, my lord, given to me in exercise of that order. My lord, I'm not on that order is bad or that order should be set aside. My lord, they will have to get the time extended from the court of CMM, and then only the notice can be given by the commissioner to me, giving a date for execution of that order. That is my contention. I am not on that order itself is a bad or bad on that ground or this ground. The read court is not the forum for challenging that order too. I have another option. I will challenge that order before the appropriate forum. But this order, this notice itself is a violation of natural justice and beyond the law, and which is not permissible to be sustained. Once they want to put me under notice for execution of that order, they will have to get the time extended, and the fresh warrant is to be issued by the CMM. That approach they will have to make before the CM, and that only then and thereafter they can issue that notice. And that notice is bad under the law, and that is why I have challenged it before your lordship. I'm not on that order passed by the CMM is bad or good. That is not this is not the forum for challenging that also.
Yes, read the judgment which you're reading.
My lord,
Read the judgment on which you're relying.
on the relevant part, my lord, once again, an essential component for judicial order.
Which page? Which page?
Paragraph 6. Paragraph 6.
Yes.
Paragraph 6. Paragraph 6. The second subpara. 31 within single inverted comma.
Yes.
Yes, my lord. An essential component of judicial order is certainly if a CMM imposes a time limit. Here the CMM imposes a time limit for taking over possession. Such stipulated time has to be mandatorily adhered to. There it has not been adhered to. We waited. Thereafter, the last date of execution of that order expired. Then we approached before the tribunal. Then we obtained the stay order. So, the mandatorily adhering of the order has not been followed. If the same is not done, be it for whatever reason, the appropriate cause of action is to reapproach the CMM concerned for extension of time. For whatever reason, if that fails, they will have to reapproach the CMM for extension of time for execution of the warrant. That they have not done. When if your lordship kindly sees the subsequent dates, what order they have, the order has been passed by the CMM's court, they have not even prayed for. We are there. We are of the clear view that reasonable time limit should be imposed by the CMM in their wisdom and discretion. So it is the discretion of the CMM who will fix a further date for execution of the order. And I have not challenged the parental order before your lordship. I have challenged the notice which is given to me on the strength of the warrant issued on the strength of the order dated 22nd of August 2023.
Yes.
And that is my one contention. And second, second part is so far the commissioners, advocate commissioners part is concerned, that I want to also place.
Yes. Yes.
Yes, I want to place. Unreported নয় এটা দাঁড়ান আমাকে দিয়ে দিচ্ছে একটা মামলাটা করতে দিন
What brings you, Mr. Banerjee, here? Oh, that you're appearing in that matter?
Unreported না স্যার না না লুকিয়ে কেন রাখবে
Tomorrow?
লুকিয়ে কেন রাখবে আমাকে
Tomorrow we can try to answer. What is the urgency?
Which we are challenging. So the bank was twice advertised for good financial experience in all those papers, and then they withdrew the same. Third one, when they advertised in the paper called Info of India. I think I have not heard what that paper is. And someone in Bengali, another paper again, which are not thinking. And then I gave it to over they would give at a price of about 9 crores a lot. We have 16 crores it's a challenge to the same.
It is already handed over.
That we do not. So when we wrote to the bank only wrote to us saying that we have introduced nothing else.
So then you have to make the third party right has been created.
They have not when they made the third party the petition as per the.
Today, I don't think so. We can reach till.
Whenever I get tomorrow, the urgency is that I don't want further rights from production. If I'm right, there's further rights from interim. That's the only condition. If tomorrow is possible or today wants me to come back or
Try your luck at 4. Yes.
If your lordship kindly sees my certified copy, last but 5th page.
Yes.
Last but 5th page. The affidavit page.
Yes.
This is the application under section 14(1) filed by the bank. The affidavit page your lordship kindly sees identified by me, prepared in my office, the signature and the enrollment number.
You're showing the last page, huh?
Affidavit page, last but 5th page, 5th. Last but 5th page.
The
Affidavit page, affidavit page.
F952.
If your lordship kindly sees identified by me, prepared in my office, A. Bhattacharya.
May I have my lord's leave to make a submission, my lord? I was appearing for the bank, my lord. I'm very sorry, my lord. I have a matter fixed at 3:30, my lord. Would your lordship kindly grant me leave? My junior is there, my lord, before the Honorable Delhi High Court.
Somebody is here, Mr. Banerjee.
Yes, but my lord kindly will. Yes, my lord. He is my advocate on record in this matter.
I am led by Mr. Shatrugh Banerjee.
So you are not.
My lord, I'm not. I'm in Delhi, my lord. My matter is fixed at 3:30. If your lordship hears him and keeps it tomorrow, I can come back and give the reply. I don't want to take a time, my lord. But
All
since
right,
it is already
let me hear him, then we can fix it for tomorrow.
grateful, my lord. May I take my lord's leave, my lord? Grateful.
আরে দাঁড়ান আপনাকে দিয়ে দেবো আপনি নিয়ে যাবো না বাড়ি আপনাকে আমার মামলাটা করতে দিন
Yes.
আনলিমিটেড নয়
No, I'm not able to follow this argument of yours. I'm not able to follow this argument.
Only your lordship kindly page on the affidavit page your lordship has got it.
This is the last, no? Affidavit.
Yes.
This is
Identified by me, prepared in my office. A. Bhattacharya. Your lordship kindly sees the enrollment number.
Advocate.
Yes.
Yes.
Well, this is the application filed by the bank under section 14(1) on behalf of the bank. He is the advocate on record, rather advocate, filing advocate. Now your lordship kindly see who has appointed as the advocate commissioner. Though this is not the part of challenge before your lordship in jurisdiction, your lordship kindly sees this is the conduct.
Yes. This was not before the DRT.
This was before the DRT, but DRT hold that they couldn't find anything. I don't know, Malad. I don't want to. That is the observation, Malad. We will challenge it before the revisional court CO, filing CO. We have prayed for a certified copy also.
Yes, sir. Anything or tomorrow?
My lord, Mr. Shatrugh Banerjee is appearing
Tomorrow.
tomorrow, my lord.
We'll have it tomorrow. This matter we'll have it tomorrow. Let him give his argument. Keep it tomorrow.
Tomorrow in the
I know this will be in the morning. Keep it in the morning.
আপনি এত ইয়ে হয়ে যাচ্ছেন
So there's the original side matter. So we'll finish off the original side and then we take.
না দেওয়ার কোনো কারণই নেই, কেন দেবো?
Shatarup Banerjee, Mr.
Well, I did.
Ni- 19th April was the date. But after receiving the notice of this writ petition, they are
স্টে কালকে সকালে হলে স্টে আসবে। Good.
Call the regular matters. Yes, Mr. Chakravarti. Where is Mr. Mukherjee?
he will come, my lord. He knows, my lord. Possibly waiting for appellate side matter.
Yes, let's put the number on the board.
My lord, kindly see, my lord, they are
Put the number on the board.
My
That's the
lord.
number we put on.
item number 3, item number
Item display karo.
12, 12.
Item display karo. Mr. Mukherjee is here.
But I'm placing, my lord, affidavit in opposition filed by the Kolkata Municipal Corporation. Lordship, once again, I'm drawing lordship attention, page 13. But the inspection book, that I've really applied my mind and it comes to my lord, my realization is, my lord, it's absolutely, my lord, ARV method prior to introduction of, my lord, the area-based taxation.
So I was right in pointing it out.
Yes, my lord. The only thing, my lord, kindly see, fourth quarter 2016-17, the left-hand side of this honorable court, middle portion, annual value is revised, so and so, so and so, so and so. Existing so and so. Next column is proposed.
Yes.
Then, my lord, at the bottom, no signature, nothing of this kind.
That we noticed.
Yes, my lord. Decision of the hearing official. Then, my lord, I'm coming. Then, lordship, kindly see, my lord, they have enclosed certain documents of inspection book without enclosing the order of the hearing officer. Without enclosing, lordship knows, my lord, for preferring appeal, one is required in terms of the rule 10 of the taxation rules to, my lord, enclose, my lord, the copy of the order. Now, lordship, kindly come to no hearing notice, nothing of this sort in this affidavit. Then, lordship, kindly come to, my lord, page 26. Here also, the valuation was made in our absence, ex parte. My lord, there are two columns. Top one, the bottom one may kindly be looked into, where it is written for office use only. Page 26, let's have got it, of the affidavit in opposition.
Yes, page 26, right?
26.
Yes.
At the bottom, lordship will find, my lord, for office use only.
Yes. So difficult to read actually.
My lord, the document they have filed.
Yes, for office use only, yes.
We have, my lord, AB, the AB is decided within bracket ex parte.
Yes.
Then lordship turn to 31. For office use only, here also ex parte. And 35 also, my lord, ex parte. And lordship, then, my lord, kindly see they are claiming, kindly see the 219 within bracket 1 notice, that is page 12. I am putting this, the page 12 of the affidavit in opposition.
Yes,
Tanbir Abedullah,
yes.
Ibadullah, 7/1 Topshire, SSC number so and so. Then quarters, third quarter 2008 to my lord, fourth quarter 2023. Here I intend to raise one question in terms of the section, my lord, 573. My lord, the Kolkata Municipal Corporation is not permitted, my lord, to claim anything beyond 3 years. And our honorable division bench was kind enough.
Why
You-
you don't have a provision which allows you to open them for as long as they wish to, if it is found that they have not filed it in accordance with.
My lord, we have taken that plea. In our writ petition, we have taken that plea. And it is supported by division bench. They prefer appeal before the Honorable Supreme Court. I think, my lord, one day I am sitting here. I have heard, my lord, Mr. Abhutosh Majumdar was arguing one case of this, my lord, in spite of that particular division bench judgment, which was, my lord, ultimately upheld by the Supreme Court, review which was rejected. In spite of that fact, my lord, in Saujoin Charitable Trust, the KMC is trying to realize, my lord, the tax in the similar fashion and way by amending the act. Well, that was challenged before the virus was challenged. Well, that
Judgments.
no judgment is yet to come. Lordship is kind enough to hear this matter.
No. I want the.
I'm showing. That Shaujan I'll show. Just I'm trying to, my lord, the factual aspect, my lord. Then Lordship, in our reply, my lord, we have taken specific, my lord. Kindly come to, my lord.
Reply of what?
Reply of this affidavit in opposition filed by the Kolkata Municipal Corporation.
Do we have it? We don't have it, sir.
Yes, my lord.
We don't have it.
Reply jama koren. I have to excuse my lord.
I have the reply. Exception to the reply.
Sorry?
I have the reply.
They have served us.
Yes, my lord. This, my lord, I may be excused.
You're lucky.
My lord, I may be excused, my lord. This is my mistake I have committed. Kindly excuse me.
Yes.
Kindly come to page 4.
Yes.
Page 4, my lord. Last paragraph.
Yes.
Your petitioner further states so and so that your petitioner went to the office of the concerned department for submitting to demand draft of 20,95,000 towards payment of the outstanding property tax in respect of the 5 SSC number in question. Your petitioner was verbally threatened by the official of the said department, and in view of the huge outstanding property tax against the said 5 SSC number, the corporation authorities would issue distress warrant, and consequential steps shall also be followed against the said property so and so. So, my lord, our allegation is this: threatened us and forced us, my lord, to undertake before the authority. My lord, in their affidavit in opposition, they have denied it. This is their suggestion, as if they are trying to depict it as a suggestion, and I have accepted the suggestion. And my lord, I have done this undertaking in presence of the other high officials. Then, lordship, kindly see, my lord, page 5 at the bottom. Page 5 at the bottom, with regard to the annexure R2 and R5 to the said opposition. Your petitioner said that this document relates to other 4 apportioned share from the extract of inspection book of the KMC in respect of the 4 SSCs. It would be evident that the last valuation of the respective SSC have been determined and fixed ex parte behind the back of the petitioner. Lordship knows, my lord, after the hearing is, my lord, taken place, even if it is ex parte, my lord, copy is required to be served to the SSC within 30 days from the date of taking decision. My lord, they did not produce a scrap of paper, my lord. Neither notice nor, my lord, the copy of order they have sent to us, my lord, not in their affidavit in opposition. What is more, they have enclosed certain document of under certificate of posting showing that their raised bill, that is page number, lordship will find once again, and 15, page 15, putting lordship once again in trouble, my lord, to look into the affidavit in opposition. Here they have enclosed certain, my lord, documents which is under certificate of posting. My lord, the Honorable Supreme Court sounded note of caution so far under certificate of posting is concerned. Here also Honorable Division Bench, my lord, very recently observed, my lord, where, my lord, Mr. Ghosh was the lawyer of the appellant, my lord, under certificate of posting not accepted. My lord, even assuming for the sake of argument valuation was taken place, My lord, no document so far notice is concerned, no document of under certificate of posting. They have enclosed certain document of sending bills. So if valuation is yet to be finality, they cannot raise the demand. Even if they have raised demand, should not be in the under certificate of posting. My lord, there is no deeming provision, no legal fiction is permissible so far, my lord, the post is concerned. I intend to rely upon two judgment, one by this honorable court, division bench, and one by Supreme Court. Now, lordship, I intend to place, my lord, the judgment. My lord, the outset, my lord, how join charitable trust.
This last part I didn't understand. What
Lord-
were you saying?
Lordship,
You repeated the last portion of the argument. What were you saying?
my lord, while my lord sending notice before hearing, my lord, they are to serve us notice. For serving notice, there is a provision under the Kolkata Municipal Corporation Act. It should be sent through under certificate of posting. And if it is sent under certificate of posting in their own law, they have, my lord, it is to be considered as a deemed service. 184 proviso, I'll show, my lord. I'll show, my lord, the provision of the law. And, my lord, our humble submission, this was considered by the Honorable Supreme Court and Honorable Division Bench of this Honorable Court. My lord, it was not sounded a note of caution that this is not a actual mode of service and all this. Very recently by the Division Bench. And in a separate matter, Honorable Supreme Court was kind enough, my lord, to make this observation. Here, my lord, they did not enclose any document substantiating that they had sent notice even under certificate of posting. This is one aspect. They had, my lord, enclosed certain document. So for sending, my lord, the realization process is concerned under certificate of posting. Our humble submission, my lord, subject to correction, these under certificate of posting not to be accepted, my lord, as a good service. My lord, correctly paid, properly stamped, that presumption is also not applicable. When it is registered, then that particular presumption of the General Clauses Act will be applied. Just I'm showing, my lord, 184, where this particular deeming provision is there. My lord, 184 of the KMC Act.
Yes. Public notice and
Explanation. A written notice under this section shall be deemed to be duly served if it is sent to mode of service of Indian Postal Service as may be decided by the corporation. So here they have decided to send it under certificate of posting, which was deprecated by the Honorable Division Bench in a very recent matter. I'm showing that judgment first. Kindly see, my lord, this is Chapon Kumar Ghosh versus Kolkata Municipal Corporation. Citation it to be, I don't know whether it was.
yes.
But I'm drawing lordship attention, paragraph 36. Well, the two stalwart of the Kolkata Municipal Corporation was, my lord, before the Honorable Court.
I beg to differ from him that I am not a stalwart. Might be someone else, he might be other words, but I am not.
Paragraph?
Paragraph 36. In that view of matter, we are of the considered opinion that KMC is not entitled to rely upon deemed service provision in section 184 of the KMC Act. Therefore, and also because actual service could not be established by KMC, we are constrained to hold that no notice of alleged hearing dated so-and-so was served on the appellant. Hence, the order of hearing officer passed on dated so-and-so, confirming the proposed enhanced valuation of the concerned party is bad, null and void, and non-est in the eye of law. The relevant order of hearing officer stands set aside. Then, my lord, paragraph 38. Here, my lord, we are conscious that an order of hearing officer is appealable before the municipal assessment tribunal under section so-and-so. The writ court would not interfere if an efficacious remedy is available to the writ petitioner. However, it is right law that existence of alternative remedy is not a bar to the maintainability of the writ petition. Then, my lord, the ex parte hearing taken place, my lord, set aside by the Honorable Court. Here also ex parte. Here also on the basis of under certificate of posting. This is my first full submission as far as judgment is concerned. Now, Lordship, kindly see the undertaking. PS related. The undertaking, my lord, they have forced us. That is also PS reality matter. This is reported, my lord. This is reported. It was challenged against, but division bench not entertained. Here also, my lord, the petitioner, well, just one copy, I'm handing it over. Petitioner submitted a declaration and stamp paper. My lord, I may be excused, my lord, for that. Page number 3, accepting the above assessment of valuation of the said premises for the period mentioned herein. Supplementary bill were raised. Here, my lord, the fact is, my lord, the corporation people forced petitioner to furnish a 10 rupees stamp paper accepting the annual valuation. My lord, the observation of the division bench and honorable writ court was, since it is not provided in the 4 corner of the act, KMC cannot do it. I am relying upon page 5 and 10. I may be excused once again. আমি দিয়ে দিচ্ছি তোমাকে এক্ষুনি দিয়ে দিচ্ছি হ্যাঁ I intend to develop my habit from some other persons, those who are yes. Then my lord, Sahujoin Charitable Trust. Lordship, kindly see.
Yes.
Here, my lord, page 3. This is also reported, my lord. I may be excused, my lord. I will, the next time henceforth, I will bring, my lord, the reported judgment. In the instant writ petition, the appealant writ petitioner have fought for a declaration that the second proviso so-and-so is ultra vires in Article 14 of the Indian Constitution. Furthermore, the assessment order dated 16 November 1999 for the assessment period of 4th quarter 84-85, 3rd quarter 1990-91, 4th quarter 1991, up to 3rd quarter 1996-97, 4th quarter 96-97, up to 4th quarter 1990-2000 be quashed. So, my lord, they have decided to, my lord, the undertaken, my lord, the annual valuation of a particular premises for number of GR, general revaluation. Finally, my lord, this was taken into consideration by this honorable court. Page, my lord, 6. First paragraph, second, third. We adopt the same procedure. The commissioner can only have the power to revise valuation within a reasonable period of time. In case of so-and-so, my lord, the Supreme Court computed reasonable time in subject act to be 3 years. In section 573 of the Kolkata Municipal Corporation Act, the corporation has the power to recover any sum by initiating a proceeding within 3 years from the date such sum became due and payable. Therefore, on a proper interpretation of the proviso, upon reading it down to save it from unconstitutionality, the period of which valuation of a property can be raised must not be more than 3 years before the date of revising the order. So, my lord, 573, just I am reading, and my lord, I will conclude my argument. Lord, 573 of the Kolkata Municipal Corporation, with the leave of this honorable court, I am reading. Save as otherwise provided in this act, or the rules or the regulation made thereunder, any sum due to the corporation on account of in change, cost, suspense, expense, fees, rate. My lord, the fees, my lord, usually the assessee of corporation has been termed as rate payer. They are the rate payer. My lord, that definition in the definition clause is available. Or rent or any other account under this rate, act or rules and regulation made thereunder shall be recoverable from the person from whom such is due as it was as a property tax, provided that no proceedings for the recovery of any such sum under this section shall be commenced after lapse of 3 years from the date on which such sum became due. So, my lord, that being the situation, and my lord, I'm just rate payer. Kindly see, my lord, section 272.
Clause
2, section
subsection
72. Clause 2, section 2, clause 72.
Section 72.
Lords. Definition clause, my lord. Here, my lord, ratepayer means a person liable to pay any rate, tax or license fees under this act. So, my lord, our humble submission, my lord, in view of the provision laid down under section 573, and in view of the provision, my lord, the KMC cannot do anything unless it is provided by in the law. And my lord, they are claiming, my lord, their huge demand for a considerable period of time. And my lord, the valuation made ex parte without serving us notice under certificate of posting, my lord, is not taken into consideration.
But what about the undertaking which you gave?
Lordship, this is my humble submission.
What about the undertaking which you have given?
Undertaking, my lord, this is
59 page 59.
আমাকে building rules team, শ্যামল কোথায় গেল building rules? মানে there must be clear cut specific provision in the act. In building there is provision where I will give undertaking at a building rule.
That's a different undertaking, sir.
Yes, my lord. That is statutory undertaking.
That is statutory undertaking when you have certain clauses which you, when you
Yes, my lord.
applying for a building permit, then you give undertakings.
Yes, my lord.
We are talking about the undertaking which you are given here that you will make the payment.
Yes, my lord. My lord, they cannot force me. We are there, my lord, to deposit certain amount.
You are saying that they are forced you. What evidence do you have?
My lord, I have relied upon a judgment of PS reality, my lord, which was challenged before the honorable division bench. My lord, the same judgment as held by the honorable writ court. So PS reality for undertaking related issue, 573 for a long period, and my lord, under certificate of posting, division main judgment, my lord.
Which paragraph of PS reality?
PS reality, my lord.
Paragraph
My lord, only one copy. At the top, my lord, have written the page number. Lordship, kindly see, I may be confused.
No.
Lordship, got it?
Oh.
But maybe.
Over here?
Yes, my lord.
Like this?
Yes, my lord.
I thought it's a design.
Yes, my lord. I may be excused, my lord. It is reported. I should bring the reported judgment. Henceforth, my lord, I undertake also. This undertaking is legal, my lord. No force, nothing intimidation, no coercion, nothing of this sort. This is my mistake, my lord. Kindly excuse me. Should not, my lord.
The judgment has no paragraphs.
Or, my lord, allow us, my lord, to, my lord, supply the reported judgment tomorrow. A day may kindly be given. It's a reported judgment. Everyone knows. Mr. Mukherjee was the lawyer of KMC.
Yes, Mr.
Tomorrow, my lord.
My lord, may I give reply on next Thursday? Because he has relied upon 3 judgments. I'll make my comment showing the judgment, but to start with, just to start with.
I thought we'll finish it.
Very well, next Thursday. I'll start it next Thursday.
Listed for further hearing. Heard, listed for further hearing next Thursday.
Deeply.
ये रख दो, bye.
Item number 13.
May I please? But on the last time, Lord, I have argued in detail in this matter, my lord. This pertains to my challenge to a retrospective revised assessment of property tax and imposition of, my lord, annual value and imposition of property tax, my lord.
Why are you here? Why don't you go to the tribunal?
My lord, it is a case, my lord, where I have, my lord, on the last day also I argued that they have not given us the notice under section 184. We have filed the reply under 186. They have not, my lord, considered my objection nor given any opportunity of hearing to me. If your lordship kindly once takes up the notice at, my lord, page 89. It is the case, my lord, where I was, my lord, occupying the property as a lessee. A suit was pending before this honorable court under the original jurisdiction, my lord. In that suit, my lord, I have filed an application for vacating the premises. The honorable single bench has allowed me. Thereafter, the honorable division bench has also confirmed that judgment, pursuant to which, my lord, I have paid the entire dues till my vacation of the property and the last quarter of 2022, and thereafter vacated the property. Subsequently, my lord, under section 183, I have filed an application for removal of my name, since I am not in the property. At that point of time, my lord, they have issued this notice and said that no, there will be revision. So kindly, my lord, take, my lord, that 89
In the middle portion, my lord, municipal commissioner will proceed to consider such valuation on 19/2/2023 at 2:30 p.m. in the corporation office at blank. Please note that you may submit objection in writing, if any, under section 186 of the Kolkata Municipal Corporation Act 1980. Against the above. So, my lord, what happens in this kind of hearings, my lord? Generally, a hearing officer is assigned. But in my case, my lord, no hearing officer was assigned, and the premises where at the venue where it will be held, that was also not mentioned. Thereafter, my lord, I have filed my reply, my objection to the assessment. That is in the next page, my lord, page 90. Your lordship has heard the matter, my lord. And if your lordship kindly takes up their one document which transpires from their website, my lord, it is at page 95. The SSC number is of mine, my lord. I can, my lord, tally that also, my lord, but hope that will not be, my lord, objected. My lord, that is the SSC number.
Which page?
Now,
Page?
page 95. It is a my lord, printout of their website, Calcutta Corporation's, my lord. Your lordship has seen that in the notice, the date of hearing was given as 19th February 2023. At page 89, I was called for hearing on 19/2/2023 at 2:30 p.m. But no hearing officer was assigned on that date. So if your lordship sees this last entry, that is on 19/7/2023, hearing time 0000, quarter such and such. Hearing, the next column is for hearing officer, my lord. It has not come like that. My lord, I can show it from laptop is required, my lord. Hearing officer, laptop. This is a hearing officer, generally 6, hearing officer 6, 14, etc. Then. So on 19/7, my lord, kindly note 0. No one was there. And the result, hearing status was pending. So from 19/2 to 19/7, my lord, nothing happened. It was pending. Now, my lord, kindly see the next page, my lord, page 96.
Yes.
That is a bill, my lord, which I have got from the person with whom I am litigating, from a third party who has, my lord, claimed some amount for the dues towards the period when I was in occupation on the device charge. My lord, hearing date, kindly note that hearing date in this bill, my lord. 19/7/2025. Thereafter, my lord, representation date 26/7/2023. I don't know, on these days I have never appeared, my lord. I have made categorical assertion on oath in my petition also, and I have made several letters to them also for non-consideration of the objections. And my lord, a revised assessment made, my lord, revised property tax was imposed. In the next letter is my, my lord, 25/7, where again I have made a detailed representation specifically contemplating that after lodging my objection under section 186, it was not considered, nor any hearing was given. So please let us know what is the fate.
Yes.
So upon considering all these aspects, my lord, on the last day, your lordship was kind enough to direct the KMC to produce the records as to whether the opportunity of hearing was given to me or my objection was considered at all or not. So, my lord, they are supposed to, my lord, bring this.
Well, I have taken instructions, and also illogically see what is his grievance. His grievance, entire case is in paragraph 39 and 40.
His grievances, he has not been heard.
No, I have not given a hearing. Because, my lord, he is right,
You have given
and I have no claim also against him. I have also no claim against him. Because, my lord, he was in the property as a lessee up to 2015. He continued to be in possession. Well, he ought to have immediately informed to us that his lease period has expired. Somebody came into the property with effect from 2015 as a lessee. Then that gentleman subleased to other persons, Singania company. Now, my lord, he has no interest in the property, and I have no claim against him. Since his name continued because of no intimation to us, his name was on our record. That is the reason we issued the notice in his name. But in the meantime, the person who has obtained the lease and sublease, they approached to us and requested us to assess the property. And we have assessed, and whatever the demand has been there, they have paid it to us. Interest for the property. We have no claim against him. We are not asking any amount from him. But I don't know, because his demands is that because third party for which he continued in possession, he is asking that amount from him. That is his personal dispute. Because the other person who is the lesser subleasee, they are asking that you pay the amount. Therefore, that is his.
Put this on record, we'll finish it off.
But I have no claim against him.
So kindly see page
I
87
have
once.
stated.
Let him put this
I
on
have
record.
given them intention for deleting my name.
Yeah, but he has
Thereafter, they have
also,
issued notice.
he also.
And now the person is sending notice to me that this is this part.
That is
your
it,
period.
between the there.
With him. As far as the property tax is concerned, he has raised an assessment, he has received the money. There is no claim as far as.
I have no claim against
But
him.
today what happened, I am telling you, my lord.
If you have any personal dispute, private dispute with
But that
somebody
is,
else,
that is,
you sort it out
my lord,
elsewhere.
that is pending in a suit. That is, my lord, not the
No,
subject
you
matter
say
here.
That is the kind of
It's not
subject
the
matter.
What is your grievance today
My lord,
against the
kindly come
corporation?
to page 87 once, my lord. When they have,
And you know,
Why I have to come to-
you know, look at the page 87, his application.
Yes. What
He
is the
said, my
problem?
lord, remove my name. And
Yes.
I should not be held
That is my
responsible
case. After
for tax any.
after vacating the premises, my lord,
Yes.
I have issued this notice under section 183 intimating that please remove my name because I am no more person liable.
Sir, today you are
At
making
that
a-
juncture, he has issued the notice. After this, they have issued this
That
notice.
is because
Not
that was
before
not
this.
done immediately. That is the reason
They have issued a notice
There's
under
no-
184.
nobody is
It has
objecting.
to reach a logical conclusion.
Sir, he is saying that as far as the notice is concerned, they have already received the money as far as the property is concerned. You have nothing to do with it.
Yes.
And I'm not asking from him, my lord, any amount.
Must kindly appreciate the difficulty. Today, he is asking for an amount for a period
He is
during
not
which
asking,
I am a
he is
government
not
company. my lord.
asking from you. for
My lord, he
any
is not
amount.
asking from me. That's fine, my lord. Must kindly appreciate one thing. My lord, today, my lord, I am a government company. He is asked, the revision has been made for a period during which I was in occupation. Now they have given a,
You won't file a suit. Get your recovery done.
my lord, the recovery,
Get your
my
recovery
lord,
done
not the
from whomsoever you want to. Mr. Ghosh, you put this on record, we'll dismiss it. He has no case.
But his
But if-
application will also once, my lord,
You have to file this on affidavit so that I can dismiss
is
it.
at page 87, once your lordship looks at his application,
Page 87.
Mr.
my lord,
Ghosh,
my lord,
file your affidavit, we'll dismiss it.
my lord, as your lordship.
Just put this on record. 2 weeks.
2 weeks, your lordship.
Learned counsel for the respondent seeks 2 weeks time to file his affidavit in opposition. Reply to the same if any within 1 week. List after 4 weeks. We'll finish
Sure.
it off.
My
Yeah,
He has
for
no
10
case.
days only instead of 7 days, my lord, 10 days.
7, you have no case. It should be dismissed right now, but I don't want to put Mr. Ghosh in problem. Let the affidavit come on record.
Let it.
No case at all. You are settling your private disputes. No case,
So
sir.
if your lordship
No
finally
case.
holds that
You
they
are
have no
just
claim, the
arguing
corporation
here,
has no
there,
claim against us.
nowhere. You know very well that the payment has already been made. You know the facts.
But that
You just
payment
took the
made by
court for
some
a
other.
ride. You wasted my time.
My lord, I'll come back, my lord. Let
I
them-
wish
let
you
them
were more
produce the record,
honest
my lord.
and more candid by starting your argument with this, that this property payment has already been made. I don't have any
My lord, on the last, I have shown their demand letter, my lord. The demand letter of the third party.
On-
I have placed that, my lord. But there is no hide and seek, my lord. It's
What
a
is your
government
name, sir?
My lord, Arnab Chakraborty, my lord. But I will be candid enough to disclose everything. I will
Not candid enough. Sorry.
my lord, I'll not
You were not candid. You were not fair to the court. Let me be very
my lord,
clear
my lord,
about
that will be a, my lord, really a harsh comment
it.
on
It
me.
is harsh.
My lord,
It
I
is
have
harsh.
placed that letter also and said
wasted
that
so
the
much
third
time.
party
You know
has,
exactly that the property tax has already been paid. If you have any dispute, go and settle it somewhere else. Don't use this forum to settle your personal disputes.
it is
And
not
you
my
will be
personal
more
dispute.
fair if you withdraw this case on instruction.
My lord,
Thank you very much.
let me
Thank you very much.
consider their my lord,
I'll impose cost when I dispose it off for wasting the time of the court. Mr. Banerjee will have it tomorrow. Tomorrow I am taking one original side matter. I'm taking one original side matter so that we can have this also.
my lord, kindly don't
So
take
we'll-
me, amiss, my lord. Kindly don't take me, amiss,
Be
my lord. I
fair to
maybe,
the
my lord,
court, sir. Be
there may
fair
be
to the It's good you want to impress your clients, but be fair to the court also.
But I always try to be them. I always try to. If that, I'm apologizing for
Make
that.
your submission, make honest submissions to the court.
Kindly don't take me.
We'll have it tomorrow.
Any type example?
Well, in the morning. In the morning, I have one original side matter. So I'll keep these. There are two
45 and 46.
45 and
46.
आगे तो appeal से नहीं बैठा.
before appellate side. 10:30, we will start before the appellate side. Send the files.
वो primary.
Item 14, I appear for the petitioner. I beg Manoj leave to appear online. I was being led by Mr. Vikas Ranjan Bhattacharya. He had to leave for Parliament. I was only humbly praying if I'm sorry. I'm only seeking to have the matter adjourned till next week. If Manoj kindly chooses.
Mr. Mukhopadhyay seeks an adjournment on the ground that the senior counsel is busy in some other court. So let this matter be listed.
I cannot oppose.
You can, you want to. So, Bapu, I know you will not oppose. Let this matter be next Thursday.
Obliged. Deeply obliged.
Item number 15.
But I beg to appear on behalf of a petitioner. But in instant case of unauthorized construction, I have made allegation before the Kolkata Municipal Corporation, yet to be redressed.
Madam, for the state, madam.
My lord, I am appearing for the KMC, my lord. I have been led by Mr. Gopal Chandra Das, my lord, my senior.
Lord,
Item
my-
number 15, my lord.
Lord, I am for
Why?
the.
Mr.
My,
Das is there
my
before
lord, my
you.
sprain feet, my lord, I couldn't attend physically, my lord.
Mr. Das is
As
already
per
here.
doctor's advice, my lord, I had to be on VC, my lord.
My premises is 78 BL Shah Road. Southern side of my premises, my lord, they have made certain construction for which I have raised my voice. 78 BL Shah Road. Then lordship turn to page 39, annexure P3. The photograph will show, my lord. They have done construction, including a temple, my lord.
Where's the temple?
My lord, kindly see page 39, photograph number 4.
Seeing it.
Small temple. And my representation before the municipal authority, page 45, annexure P5.
This
I-
you are saying temple, this one.
Last one. Yes, my lord. And construction also as well as temple construction. Photograph number 2, my lord. 1, 2, 3, 4. And my lord, kindly come to my lord, page 45. That is my representation address to my lord, Kolkata Municipal Corporation.
Mr. Mukherjee, what? Decide his representation? No?
No, let that be done. I
No, no.
don't stand in the way. What I say is, there are two suits. The same issue is pending before the Alipur court.
But that
My suit is a prior suit.
suit, right?
Yes, suit pending, where this particular issue is also at large.
Issue
This-
of unauthorized construction.
Only.
Cannot be.
As for the, I have got the plate with me. Your lordship sees. This is the suit, title suit number 20267 of 2014.
Are they-
Signed by Leonard Fresh
Have they made Calcutta Municipal
No.
Corporation?
Calcutta Municipal Corporation is not a party, your lordship.
Then they-
Kindly declares it.
Then they can do nothing.
And they
They can
reported judgment of paragraph 2.
When-
Even
If
if
there is an order, nothing can be done. It
Yes.
is demolition action. Calcutta Municipal Corporation has to be a
So
party.
the corporation can only proceed with the demolition
Only.
since it is the subject matter of a suit. It can be only done after that because it is
No.
at large. My suit is a prior suit of 2013.
Mr. Mukherjee,
This suit is of 2014. Right. And all these things are pending. If the corporation wants to hear it out, there are two issues. My learned friend has not said. There are two things. One is illegal construction, as he said.
I am only concerned about.
The other thing is encroachment.
Encroachment also I am concerned if it is public land.
If it is private property or a
Public.
public property. My lord, it is not an, it's so far as the encroachment part is concerned, we
Mr.
guided
Das.
by the. Again,
I think
have
Mr.
one-
Das is.
I have one report, and my lord, honestly speaking, my lord, picture shows that this is used as an avenue to settle the private dispute. This is my reading of the whole petition. If your lordships kindly see the second, that is very poor. That is old.
All right, when was this construction taken, Mr. Chakravarti?
But very recently, my lord.
No.
Very recently.
Pictures don't show they are recent.
In his suit, he has given the photographs.
My lord,
And he
after
said he has-
after 2014, my lord.
2014, we are on 2000.
So
My
what?
lord, as
So
per
what?
the report, my lord,
What?
no new instruction, no new constructional work has been found at the time of inspection.
Even
My lord, paragraph 2 of this reported judgment may kindly be looked into, where, my lord, the civil suit is pending, that is not bar. And at the same time, my lord, I can report unauthorized construction at any point of time. If it is reported to the Kolkata Municipal Corporation, duty incumbent upon the corporation to take action. That is also a reported judgment.
One more submission, if your lordships kindly, that is page 22 and 41. That will show the bona fide of my report and my.
The
submission
report may
to your
kindly be
lordship.
circulated.
May that is 2018, illegally and unlawfully breaking off and demolishing the front side boundary wall and hidden trespass by the Tinath shop. Why I am actually submitting this? Because of this and 31, if you lordships kindly see that only one line. That is second paragraph. My lord, third paragraph, my lord, and with the fraudulent intention to trespass into my said premises, flat of the land, broken portion, etc., etc. And suit is pending, and this is my report. And
My lord,
there is a photograph.
AMC remain thankful since we are drawing their attention. I intend to, my lord, submit paragraph 17 of this.
Mr. Chakravarti, I know you can definitely show judgments, but here
Lordship.
there is a dispute and a
Lordship.
long pending dispute.
Lordship.
The very fact that this letter has been written in the year 2000, this is more than 15 years old dispute which is going on. There is no construction which has taken place in recent times. Nothing is there.
Only, my lord, allow me, my lord, to conclude my submission with the help of two reported judgment, then lordship kindly decide. My lord, kindly see paragraph 17 of this judgment that is reported in 2005 3 CHN, page 282. 2005 3 CHN, page 282, paragraph 17.
You decide as representation.
Yes, my lord, that being the situation, why they are standing on the way?
I am not standing in the way. That is the only reason. That is why after reading the petition, that is a civil dispute. Usually saying something regarding unauthorized, I am not saying, I am not found any unauthorized construction. My time will be wasted.
My lord,
If your lordship thinks I can actually take the.
May I be permitted?
So.
My lord, may I be permitted to read paragraph 17? The delay in initiation of proceedings.
You don't have to show me this.
Lordship.
At least this much of law even we understand.
Lordship. And what is more, my lord, even if civil suit is there, that is no bar, as far as municipal building regulation is concerned.
Thank you, Mr. Chakravarti, for educating me.
Deeply obliged, my lord.
Thank you so much for educating.
Deeply obliged, my lord. Deeply obliged.
Frivolous writ petition, my lord.
At the same time, junior and senior, my lord, arguing on behalf of the KMC. My lord, hyperactive, my lord, there. To save, my lord, someone who is behind the veil.
Take down. The petition is agreed by the inaction. Petition is agreed by the inaction of the respondent municipality in not taking action against the illegal unauthorized construction raised at premises number 130/1, BL Saha Road, Calcutta.
Which is southern side of my premises, my lord. 78 BL Shah Road.
130, right?
My lord, the 78 BL Shah Road is my premises.
I know. It is the case of the petitioner that she is the owner of premises number 78 BL Shah Road, Calcutta, full stop. It is her contention that the respondent number 6 to 8 are raising unauthorized construction in the above mentioned premises, encroaching upon her premises and thereby causing damage to the petitioner's boundary wall, full stop. The petitioner had initiated civil suits against the respondent, and during the course of the said proceeding, it came to the knowledge of the petitioner that the said construction is being carried out without any sanctioned plan. She had preferred a complaint dated 10/9/2024 before the respondent corporation. However, no action has been taken so far. Full stop. Learned counsel for the respondent corporation, Mr. Das, appears and states that he is ready and willing to decide petitioner's representation dated 10/9/2024. Full stop. In view of such statement, learned counsel of the petitioner does not wish to press the presented petition and states that he shall be satisfied if the same is decided in a time-bound manner. Full stop. In view of the same, this court directs the respondent municipality to decide petitioner's representation dated 10/9/2024 within a period of 12 weeks from the date of communication of this order, after affording an opportunity of personal hearing to the petitioner as well as the private respondents / any other interested parties. Full stop. With the above direction, the presented petition is disposed of.
Gratefully, Your Lordship.
Learned counsel for the learned counsel for the private respondent states that all the allegations alleged by the petitioners are disputed and denied, and that the grievance of the petitioner, which is even alleged in the present writ petition, is also pending adjudication before the civil court. Full stop. Though he has not been able to show from the plaint that the corporation was made a party in the said civil suit, wherein any action can be taken by the corporation as far as the question of unauthorized construction and encroachment is concerned. With the above direction, the present writ petition is disposed.
Gratefully, Your Lordship.
All right.
Deeply obliged.
Oh, yes. You want me to stay?
Next one.
All right, next one.
Item number 16.
Your Lordship, I'm appearing for the behalf of the
last today?
You know, Mr. Basu, yesterday I slightly lost my cool because it was 4:40 and I was ready to listen. One of the lawyers showed me the watch. I said, we are sitting here. We are not looking at the watch. You're trying to show me the watch. There was some urgency. Otherwise, I also don't want to sit. Only in an urgent matter, if there is some urgency. I was hearing it.
But today, what is said by luck in your court?
Gold plate. 2 appearances, what for?
Adjournment sought. Again, adjournment sought.
Oh, adjournment?
Yes, sir.
Yes.
Yes, my lord.
I can't.
Since the father of the advocate for the petitioner died, I am seeking one week adjournment.
Only my lord can help.
My lord.
Not today.
Grateful to them. 1 week.
Before my lord rises, may I have
Seeking for 1 week adjournment.
Not.
My lord, only
Oh,
one
no.
indulgence, my lord, only one. My lord, Item number 41, it's there listed today. I mentioned it. Lordship was pleased with to satisfy with the urgency. I was only praying Monday, Tuesday, any day Lordship takes it up.
What is there in that item?
My lord, I mentioned, my lord, it's a willful defaulter matter. Show cause issued under the 2015 circular. Proceeding, my lord, order passed under a 2024 new circular. And my lord, I get deprived to, my lord, even exercise my right of review. Today, my lord, if the review committee, my lord, passes an order, my writ petition, my lord, is infructuous.
Nobody passes an order. Nobody is
My
in a
lord,
hurry to pass any order.
Sometimes, my lord,
Mr. Sinha's board, no?
I'm sorry, my lord.
Mr. Sinha's board.
Yes. I mentioned it. Lordship was pleased to, my lord, have it included in the list. It's today, item number 41. I was only praying, my lord.
Tuesday.
Monday, Tuesday, any day, my lord.
Tuesday.
At the top, my lord, kindly, my lord.
Not at the top. What is the urgency?
So that, my lord,
Who's sitting there to
is,
pass orders?
so that, my lord, it is taken up, my lord. That's my prayer, my lord. Kindly, my lord.